Aloha mai kako, good morning. This is the September 23rd, 2020 Land Use Commission meeting, and it is being held using interactive video conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. We're doing this to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are able to view this meeting via the Zoom webinar platform as well. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please identify yourself for the record. And also, please be aware that all meeting participants are being recorded in the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. If you do not want to be part of the record, you should exit the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. Please note that for matters due entirely outside of our own control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and be patient as we try and restore the audiovisual signals to effectively conduct meetings during our pandemic. My name is Jonathan Likeke Scheuer. I currently serve as the Land Use Commission Chair. Along with me, Commissioners Axon, Chang, Okuda, Wong, our LUC Executive Officer, Daniel Oradenker, Chief Planner, Scott Derrickson, Chief Clerk, Riley Hakoda, our LUC Deputy Attorney General, Linda Chow, and our court reporter, Jean McManus, are all on Oahu. Commissioner Cabral is on Hawaii Island, and Commissioner Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9, and Commissioner Lee Ohigashi is excused from today's proceedings. Our first order of business is adoption of the September 9th and 10th, 2020 minutes. Mr. Hakoda or Mr. Derrickson, have there been any written testimony submitted on this matter?
There have been no testimonies submitted.
On the adoption of the minutes, thank you. Is there any member of the public who wishes to testify on the adoption of the minutes from our September 9th and 10th meeting? If so, if you're an attendee to the meeting, use the raise your hand function, and I will admit you into the meeting room, swear you in, and allow you to offer testimony on this small matter. Seeing none, are there any corrections or comments on the minutes? Seeing none, is there a motion to adopt?
This is Commissioner Wong. I move to adopt the minutes.
Okay,
Giovanni seconds motion.
Motion's been made to adopt by Commissioner Wong, seconded by Commissioner Giovanni. Is there any further discussion? Seeing none, Mr. Oradenker, please poll the commission.
Thank you, Mr. Chair. Excuse me. The motion is to adopt the minutes. Commissioner Wong.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes.
Commissioner Chang.
Aye.
Commissioner Axon.
Aye.
Commissioner Cabral.
Yes.
Commissioner Ohigashi is excused. Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Great. Thank you very much. Our next agenda item is the tentative meeting schedule. Mr. Oradenker.
Thank you, Mr. Chair. Tomorrow we will be once again meeting by Zoom for the Central Maui landfill motion for reconsideration. On October 7th, we will take up the Halikua development motion to amend and the Hano Hano motion to release. That is possibly by Zoom as well. At this point, we're planning on it being by Zoom. On October 8th, we will adopt the order in the Hawaii Memorial Park matter, once again by Zoom, and possibly take up any loose ends from the Kihei High School matter. On October 21st, Right now that is open, but there is a possibility that that date will be filled by some various projects that are in the works. On October 22nd, we currently have the Newton Family Hawaii Island Land Trust motion to amend. On November 4th, we have a Hollycourt development. And on November 5th, Hawaii Island Land Trust for finalization. On November 18th, we have the Pulama Lanai matter scheduled as we do on the 19th. And in December, we have the Windward Hotel matter on Maui on December 2nd, and on December 3rd, the Barry Trust matter. On December 16th, the church matter, and on December 17th, adoption of the order for Barry Trust. And that takes us through the end of the year.
Great, thank you very much, Mr. Ordinker. Commissioners, are there any questions for Dan about our upcoming schedule? No? Okay. Our next agenda item is the continued hearing and action meeting on docket number A17804, Hawaiian Memorial Life Plan Limited, to consider a petition to amend the Conservation Land Use District boundary into the Urban Land Use District for approximately 53.449 acres of land at Kaneohe, Island of Oahu, State of Hawaii, TMK 14-5-003, a portion of Lot 1. Will the parties for dockets number A17804 please identify yourselves for the record? Remember to enable your audio.
Thank you, Chair. Curtis Tabata and Benjamin Matsubara appearing on behalf of the petitioner, Hawaiian Memorial Life Plan Limited.
Good morning.
Thank you, Mr. Chair. Good morning. Dwayne Pang, Deputy Corporation Counsel on behalf of the Department of Planning and Permitting.
Good morning, Mr. Pang.
Good morning, Chair, Commissioners, Deputy Attorney General Donna Kuna on behalf of the State Office of Planning.
Good morning, Ms. Apuna.
Good morning, everyone. This is Grant Yoshimori, intervener pro se.
Good morning, Mr. Yoshimori. Let me now update the record. On August 12, 2020, the Commission met using Zoom technology for an action meeting on this docket. The parties were provided a filing schedule for their final documents and advised that closing arguments would be heard today. From August 11th until recently, any public comments via email and written correspondence on this matter received by the Commission have been made a part of the record and posted to the website. From September 3rd through 9th, 2020, the Commission also received the following documents: the parties' stipulation and comments and objections to the petitioner's proposed findings of fact, conclusions of law, and decision in order, a DPP email noting that it was not filing objections to the intervener's proposed findings of fact, conclusions of law, and decision in order, and deferred to the petitioner on that matter, the petitioner's objections to the intervener's findings of fact, conclusions of law, and decision in order, the intervener's comments and objections, and the petitioner's rebuttal to the intervener's comments and objections. On September 14th, the Commission mailed our September 23rd, 24th, 2020 notice of agenda to the parties and to our statewide Oahu and Maui regular and email mailing lists. Now let me run over the procedures for today, and those of you who've noted in the Q&A section that you'd like to testify, this will address your concerns. First, I will recognize any written public testimony that has been received on this matter, and I will identify the person or organization that has submitted the testimony. Please note that previous testimony was allowed during the first portions of this docket, and we will allow oral testimony again today prior to these closing arguments. Following the allowing in of people who've registered to testify or submitted written testimony, I will then call for attendees in the meeting room to raise their hands if they have not registered to testify, For all testifiers, I will bring you in to the main meeting room one by one, swear you in, and provide you 3 minutes to give testimony. Following the conclusion of public testimony on this matter, the petitioner, followed by the City and County of Honolulu, the Office of Planning, and then the intervener will make their closing arguments. From time to time, I will note for the public that we will be taking breaks, approximately 10 minutes every hour. I'm now going to note the public testimony that's been received on this matter, and if you are here and present and would like to give oral testimony, I would like you to raise your hand in the attend meeting function. Pani Meatoga of the Hawaii Operating Engineers Industry Stabilization Fund. So please refrain from raising your hand till I call your name. Okay. Sorry, I'm having a bit of dual screen challenges for a second. Joy Kimura of the Hawaii Laborers and Employers Cooperation and Education Trust Fund. Are you here and wish to give testimony? No. The Ko'olapoko Hawaiian Civic Club. Would that be Ms. Cipher? Or is that a different testifier? Ko'olapoko Hawaiian Civic Club.
It'll be different testimony, Chairs Riley.
Okay. Justin Soriano. I see you're an attendee. Do you wish to give testimony? If so, raise your hand using the raise your hand function. Mr. Soriano? Nope. Marcelinda Soriano. Gloria Aria Agaran. Gloria Aria Agaran. Merle N. Wilmeth. Tim Deegan. Tim Deegan. All of these written testimonies have been received by the Commission. Bonnie Deegan. Michael Deegan. Barbara Zeisel. Ziesel or Zeisel? Barbara Ziesel or Zeisel? Again, if I call your name and you wish to testify, use the raise your hand function in Zoom. Mo Radke. Mo Radke. Cindy Suzuki. Cindy Suzuki. Deborah Stevenson. Deborah Stevenson. Deborah Stevenson. I'm going to admit you in. As a panelist, please enable your microphone and your video. Ms. Stevenson, can you enable your microphone and your video?
Okay, I've got my microphone. Let me.
Okay.
Video's not on.
Should appear as an option in the left-hand corner of your screen, right next to enabling your microphone.
Yeah. Okay.
There we go. I think we're, no, it almost worked.
It almost did.
One more time, and then we'll just accept your testimony via audio only. Are you ready to proceed?
Yes.
Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay, so please state your name and address for the record, and then you will have 3 minutes to state your position.
Okay, my name is Deborah Stevenson, and my address is 278 Kakahiaka Street, Kailua, Hawaii, 96734.
Mahalo, please proceed.
So many generations of my family have purchased plots and/or funeral plans from Hawaiian Memorial since the 1960s. They planned ahead for the end of life for themselves and their loved ones by being prepared and bought many plots in adjacent locations so that they could be close. Some died owning more plots than they needed, and those were turned over to younger descendants who, like most of that generation, planned not to be buried but to be cremated with their ashes spread. While this is no way based on statistics, overwhelming comments from my generation and those younger than me is that most of us do not want to be buried in the ground. This being said, several of my own family members have since been trying to sell their plots for over a decade, but have had not any success. A quick glance for the sale section in Craigslist shows a glut of ads advertising plots for sale, not only for Hawaiian Memorial, but other cemeteries as well. The competition among sellers to sell their plots for a decent price is fierce. I've been informed that the existing capacity of occupied plots at Hawaiian Memorial is about 63%. That means that 37% of the remaining plots are unoccupied. Currently, Hawaiian Memorial allows a maximum per plot of number one casket and one urn, or two caskets, or four urns. Years ago, my elderly parents decided they did not want to be buried, so I contacted Hawaiian Memorial to see if they could connect us to any new buyers. I was told that they do not assist in coordinating the sale of plots from existing owners. I'm sure that many of the existing owners would be happy to pay a brokerage fee to the cemetery for their assistance so sellers can unload an asset that they do not want to hold on to and do not intend to use. Instead of destroying many acres of forested property, which hosts a stream that leads to the ocean, a rare species of damselfly, and many other native animals and plants, the cemetery should look to the large number of unoccupied plots and assist owners to sell to buyers, and also to increase the density allowed in one plot. The plan to expand is yet another corporate grab at the expense of our continually diminishing conservation spaces on this island. Hawaiian Memorial should be just as responsible stewards of our lands as our residents are trying to be. I'm asking that you please deny their request. Thank you.
Thank you very much, Ms. Stevenson, for your testimony. Please hold on. For all testifiers, after you testify, we provide all the parties as well as the commissioners opportunities to ask you any questions. The intervener, excuse me, the petitioner, questions for the witness?
No questions.
No questions from the city.
No questions.
Interveners have no questions.
Commissioners. Commissioner Cabral.
Yes, thank you for your testimony. I can appreciate the concern. You referenced the sort of a lot of lots that are trying to be sold. Are you aware of any numbers of how many are trying to be sold, or how many are you personally trying to resell at this time for yourself or for your family?
Approximately 10 for myself. And I guess on a daily basis, if you were to check just a Craigslist, that's where I had just done a brief review of how many were available, not only with Hawaiian Memorial, but other cemeteries as well.
Okay, thank you.
You're welcome.
Thank you, Commissioner Cabral. Commissioners, any questions? If not, thank you very much, Ms. Stevenson, for your testimony. I'm going to move you back to being an attendee, and I will next call on Mahealani Cipher. Thank you for raising your hand. I'm admitting you to the room. When you can enable your audio and video.
My audio, there's a video, okay.
We can hear you now.
Okay, I think that's it. Okay, I don't know if you can see me, but
We cannot see you yet.
I don't know why. something. Okay, start video. Okay,
There we are. Okay, good morning. Aloha.
good morning.
Do you
Aloha mai
swear-
kako.
Do you swear affirm the testimony you're about to give is the truth?
Yes, I do.
Please state your name and address for the record, and then you have 3 minutes.
My name is Maheleni Cipher. I was born and raised in Kaneohe. I live in Kaneohe on Lilipuna Road. I don't know if you need the exact address, but I can provide that at a later time. I am representing the Ko'olau Foundation today, and I wanted to just give a little bit of introduction. I have, my family has lived in Kaneohe for many generations, and I have been a resident of Kaneohe since the 1940s. And ever since 1972, I have been an advocate for good, wise planning for Kaneohe and for the Windward Side. Even winning awards for some of my articles in the Sun Press newspapers regarding community planning. So I am totally aware of the need to find balance in planning decisions. And at that time, there were a lot of large developments planned for Kaneohe, and many of us had to fight hard against developers who had all kinds of plans to put things all over the place, all the way up the Windward Coast. And one of the things we did was get the developers to agree to limit development in the Kaneohe area to just fill in spaces and not expand large development. At that time, it was a lot of debate over why Pohainani was able to build a high-rise on conservation land. That was kind of interesting. So anyway, I'm going to proceed with our testimony now. The Ko'olau Foundation remains in strong support of this docket matter and finds the proposed expansion of Hawaiian Memorial Cemetery to be both acceptable and appropriate. Our organization is a strong advocate for the preservation of Hawaiian history, heritage, and cultural values. We dedicate much of our work to the maintenance of cultural sites and advocacy for the preservation of the Wahipana and Wahikapu, legendary and sacred places of our islands. In keeping with our commitment to support Hawaiian values is to demonstrate respect for our iwiku puna and the resting places of our ancestors and loved ones of today. That is why expanding the cemetery into lands adjacent to the current HMP landscape is urgently important. With burial spaces on Oahu increasing as the baby boomer generation begins to leave us, it truly matters to us that preparations be made for addressing this need early, before all available space is used up. In addition, the applicant's stated commitment to establish a cultural preserve at Kawaiʻawaʻi Heiau demonstrates that understanding of the need to respect and honor our cultural legacies. For these reasons, accepting the applicant's assurances of future intentions regarding historic preservation and addressing cultural concerns, the Ko'olau Foundation urges the Land Use Commission to approve this application. Mahalo for this opportunity to offer our mana'o. Mahalo.
Thank you very much, Ms. Cipher, and thank you for your persistence in ensuring that you're able to testify today. Are there questions for the witness, starting with the petitioner?
No questions.
No questions from the city. Thank you.
No questions.
Interveners have no questions. Thank you.
Commissioners, starting with Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Ms. Cipher, for your testimony. I appreciate the work you've done as a person who also grew up on the Windward Side. I only have one short question. Did you hear the testimony of the prior witness, Ms. Stevenson?
Yes, I did.
Do you or the foundation have any information or evidence contradicting what she stated, which is there is an active market for the resale of cemetery plots? And as an example, she gave, she's attempting to sell 10 plots. I mean, she raised this point. Are you aware of any evidence to the contrary?
I really am not prepared to dispute or debate with the other testifier. I am concerned that having 10 plots to sell sounds like exploitation of burial places. I'm not super comfortable with that. Usually it's something you pass on to families. So if you have 1 or 2 plots for your family members, those things make sense, but 10 is kind of a lot. So that's just a comment, but not a criticism or anything.
Yeah, I'm just trying to find out whether there's any evidence to contradict what she said. My other question is this. Have you participated in any way in the discussions between the Kolaupoko Hawaiian Civic Club and Hawaiian Memorial Park with respect to specifics regarding the cultural preserve and management of the cultural preserve?
Only very peripheral, because I don't think there has been anything seriously discussed other than a commitment made. So that's all I can say. I've been involved in those discussions.
Okay, when you say you've been involved in those discussions, what kind of discussions have you been involved in?
Just talking about making sure that the heiau is preserved. And we actually worked with the Civic Club to set up a cleanup day where we invited the community that lives right nearby and people from Hawaiian Memorial Park to join us in doing some maintenance work. And this was years ago, though. It's too bad that we weren't able to replicate that again. But that was something we had hoped to do, to involve all the different parties in a way to find peace regarding Kawaiʻiwaiʻi.
Okay, and you're aware that Hawaiian Memorial Park is a wholly owned subsidiary of Service Corporation International, which sometimes goes by the acronym SCI, correct?
I am sure, I'm reading that on some of your documents, yes.
Yeah, and do you have any knowledge, or since you're reading it in some of our documents, are you aware that sometimes SCI represents itself as the world's largest funerary, cemetery, and mortuary company?
I have no comment on that. I don't know why would I be concerned about that?
Okay. In whatever discussions you are aware of between Hawaiian Memorial Park and the Ko'olapoko Hawaiian Civic Club, has the club been represented by professionals such as attorneys, planners, or anyone like that, just so that we have a level negotiating field between the club and what might be a pretty big company?
Well, I'm a member of that club as well, as a member of the Ko'olau Foundation. So I am, I'm not a professional planner, but I have been a community planner for many, many years. So I don't think that meets the standard that you're talking about, but we're not afraid to deal with people of any level. We have done this for many years.
And that's good, because I think all of us should not be afraid of taking positions that we want to take. But last question regarding that. Since you've been a member of the club, are you aware of any specific discussions about the potential liability exposure the club would face by taking on the responsibility of management of the cultural preserve?
The club does have, both Ko'olau Foundation and the Ko'olapoko Hawaiian Civic Club, they both have a general liability insurance. And I'm sure if they need to have additional insurance, that would be, they would pursue that.
And has there been any discussion, to your knowledge, about the impact on your general liability insurance policy premiums by the fact that there is at least documented potential rockfall issues regarding the subject property?
I'm not sure the rockfall concern area, the area of concern, I'm not sure if that is part of the property that would be in the culture preserve. I'm not sure.
Yeah, I'm just trying to find out whether there's been any discussion about impact on insurance costs, or whether or not, in fact, there might even be a possibility or risk that you could not obtain insurance, or insurance would not be renewed. I'm just trying to find out whether there was a discussion about that or there wasn't.
There wasn't no discussion of that, because that's something that came up in the last few months, I think. But what I would like to say is that if the club or the foundation assumed control of these lands that are in a preserve, I think a condition would be that the Hawaiian Memorial Park would have to retain some responsibility for those kinds of conditions.
And has the Hawaiian Memorial Park, or SCI, made such a commitment to your knowledge?
Not to my knowledge. That's still to be discussed, because there's not anything firm that's been decided regarding that arrangement, any kind of arrangement.
Okay, thank you very much, Ms. Cipher,
Thank you.
and thank you as one who grew up on the windward side for what you have done for the community. Thank you. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioner Chang.
Good morning, Mahealani.
Good morning, Don.
Good to see you. I just have a question. Are members of the Hawaiian Civic, the Ko'olapoko Hawaiian Civic Club, Are they cultural practitioners of this particular heiau in this area?
Some members, not all. Some of them gather greens from this heiau. I used to take members up there to teach them about the practices and the purpose and the mo'olelo. I don't do that anymore because I can't get around too easily. I'm getting older. I don't hike too much. But there are many practitioners in the club, some of whom are kumuhula, and as such, they would be going to the heiau for gathering practices.
Have you been able to work out an understanding with Hawaiian Memorial Park that both the club and members of the club who are cultural practitioners or the club members themselves have permission to go up to the heiau and continue those practices?
Yes, we have been given permission by Hawaiian Memorial.
Do you believe whether the petitioner's request is granted or not, do you believe that Hawaiian Memorial Park will continue to honor that granting of permission to access the cultural, the heiau and those cultural resources?
I think they would honor it to allow us to continue to visit.
Okay, all right. Thank you so much, Mahealani. Very good to see you. Thank you.
Good to see you. Aloha.
Aloha.
Is there anything further, commissioners? If not, thank you very much for your testimony, Ms. Seifer.
Aloha.
Aloha. Dean Hazama is our next testifier. Ms. Seifer, I will be moving you to be an attendee. Yeah. Mr. Hazama, are you here? If so, raise your hand using the raise hand function. Okay. Christopher Delaunay from Pacific Resource Partnership, or any representative of PRP. Are you here to give oral testimony following on your written testimony? If so, use the raise your hand function in the attendee room. Seeing none, that's the conclusion of people who've submitted written testimony or registered to testify. I'm now going to ask for everybody who's in the room right now who wishes to testify in this matter to use your raise your hand function. I know that Mr. O'Connor and Mr. Matayoshi had earlier indicated their desire to testify. Okay, so I'm going to ask you to leave your hands up. I will admit you one by one, starting with Mr. O'Connor, followed by Mr. Matayoshi, followed by Judy Lemus, followed by Wilfred Chang. You should be able to know the drill by now. When I admit you into the room, you will be able to turn on your audio and video. Please do so as you're admitted in. I will then swear you in. Good morning.
Okay.
I can see you and hear you.
Aloha.
Aloha. I will swear you in, then ask you to state your name and address for the record, and then you'll have 3 minutes, followed by questions. Aloha. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Thank you. Please proceed.
My name's Robert O'Connor. I live at 46286 Ahuinani Place in Kaneohe, 96744.
Mahalo. Please proceed.
Curious if I can share my screen. Is that something I have the ability to do?
No. If you have photos that you want to submit, is that? Yeah.
I have a short PowerPoint and a map specifically that I wanted to show, but I can just speak to it if I'm not able to share it.
Let me, let me see if I can adjust that. Try to share now. I will note that if for whatever reason you're sharing anything inappropriate, I will kick you out of the meeting, but I'm not saying that you're planning to, but just giving you fair warning.
Yeah, I don't see that option on here to share.
Okay. So it should be available to you. I have enabled.
Where's that options? I see.
It should be in the
share content. There it is. Everything on your screen. Can you see that?
No, what happened was we lost your video. So Mr. O'Connor, I'm going to ask you to describe it instead. So if you can re-enable your video and describe what you have, and then provide to the commission an email what you want to share after you're done with your testimony.
Can you
So
still
please
hear me?
proceed. I can still hear you. Please proceed.
Okay. So I'm recent UH grad. I studied geography, looking at the impacts of human-induced construction and other things going on in Kaneohe Bay, and basically wanted to speak to the cumulative impacts that are going on in the bay and what this project might mean to that. Specifically, there's a couple things that haven't been mentioned in the EIS that I'm concerned with, and I don't know if they've been addressed specifically, but within the bay, there's been a lot of human-induced impacts, whether it be vessel groundings, non-point sources of pollution. Historically, you know, with the Marine Corps base and all the urbanization, there's been a steady decline in reef health within the bay. And specifically, this happens because of urbanization onshore and grading of land. And I think it's important to note that not only is it habitat to the endangered Hawaiian green sea turtle, but it is also critical habitat for the Hawaiian monk seal. And the Hawaiian monk seal is a federally protected species. And that critical habitat is just adjacent and includes all of Kaneohe Bay next to this area where this is happening. The mitigation efforts that I've seen in the EIS are not effective for mitigating this in case there's a large rainfall during the process or even after the process if it's not done right. The coral protection hasn't been addressed. If there is any sedimentation that runs off due to this project, which is likely to happen, that can serve to smother the coral and impact the fish habitat in that area. And there's also adjacent essential fish habitat, or what we call EFH, that could be impacted. And these are all federally protected areas. So I did have a map that shows all these different layers, and I'm willing to share that. And I also had some documentation about the endangered Hawaiian monk seal and why that's federally managed and what impacts this project could have to that. So I'd vote to deny this request, and I'm willing to take any questions that have to do with what I just spoke about. And I'd just like to reiterate, I got my master's degree in UH, studying the impacts such as this, also a marine scientist outside of that, and a Kaneohe resident. Thank you.
Mahalo. Are there questions for the witness from the petitioner?
No questions.
No questions from the city. Thank you.
No questions.
Interveners have no questions. Thank you.
Commissioners? Any questions for Mr. O'Connor? Mr. O'Connor, did you comment on the EIS that was done during the comment period?
I did submit written testimony at one point addressing some of these concerns, and I think that is in the public record.
Okay. Thank you. Thank you very much for your testimony this morning. Appreciate it.
Thank you.
I'm going to change your role back to being an attendee and admit Representative Matayoshi. Good morning, aloha.
Hi, good morning, everybody.
Good. Can you speak a little bit louder or turn on up the gain on your microphone?
Is this better?
That's better. Thank you.
Okay.
I know it's always awkward when I'm swearing in a legislator, but here you're just a member of the public. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay. Name and address for the record, and you have 3 minutes.
Well, I guess you can use my capital address, 415 South Beretania Street, room 331, Honolulu, Hawaii, 96813. I'm pretty sure. I usually don't know things myself. So I did submit testimony earlier. I wanted to, and I submitted additional testimony as well. I wanted to make clear that my concern is, my primary and really my main concern is the safety of the houses around the area that's being proposed to be developed. Initially, when I looked at the plan, I didn't think that there was too many. I didn't think there were too many issues, including while building. But I did talk more recently to a civil engineering friend of mine, and I had him kind of take a look at the plan as well. And he raised some concerns for the surrounding area. Just to give you a little bit of a background, I do represent this area, so I have been talking to the residents around there, and there have been issues with flooding in that area, and then that's a big concern. In fact, one of the guys who lives there had to recently dig a trench around his house because his house got flooded during the last winter rains. And as we know, due to global warming, the rains are getting worse, and we expect them to continue to get worse as well. Now, I do want to say that there are safeguards in place in the plan itself, but the concern was more in the calculations of the size of the retention basins and whether those would be adequate to retain the significant amount of water, or amount of water significant enough to prevent the flooding from the nearby houses. Legally, I think that when the area is unimproved, it's hard for the residents to argue that the flooding was caused by Hawaiian Memorial Park or to hold them liable. But if they do improve the area, then, I mean, as far as I know, Hawaiian Memorial Park will be responsible for the runoff. And I wanted to make sure that the plan adequately addressed that. As of right now, I don't think it does. Whether it will in the future, or whether they can make changes to it to adequately protect the surrounding areas, have yet to be seen. But I very much encourage that, obviously, to protect the houses. But as the plan is right now, I just can't support it. And again, this is really coming from saving the houses around the area, preventing them from being flooded. There is a house that I know of with a woman who is just too old, too frail to be really safely evacuated quickly if the water starts coming down. So that's my testimony. I did want to make sure that the commission knew that it is changed from my original testimony, just due to added information and me consulting with a civil engineering friend about it. They're also moving a lot of dirt. I mean, I'm not saying that can't be done safely, but they are moving a lot of dirt to do this too. So open to any questions. And then, sorry, I've got to go pretty soon. I've got a majority caucus at 9:45.
Okay, thank you. Are there questions for the representative from the petitioner?
No questions.
No questions from the city.
No questions.
Interveners have no questions. Thank you, Representative.
Commissioner, starting with Commissioner Okuda.
Thank you very much, Mr. Chair. And Representative Matayoshi, I will try to be fast and brief. I know your family has a long history on Hawaii Island, and I think once I told you that our family is very grateful to your great-grandfather, who was a physician who took care of my grandmother. But switching more to your presence on Oahu, how long have you been a Kaneohe resident?
I've been a Kaneohe resident for a couple of years now. My district's a little weird. It's Kailua and Kaneohe. So I lived in the Kailua portion when I actually started running for office.
Oh, okay, and I grew up in Kailua. Let me ask you this. As a state representative, have you gotten a sense of how the community feels about this expansion or proposed expansion of Hawaiian Memorial Park?
Yeah, I mean, I've got a sense of it. I also knocked on a lot of doors. You know, I want to be careful not to overinflate. Sometimes when people are shouting, it's not a majority of the people shouting, but it can seem like a lot more than are actually behind or on either side of an issue. So, I mean, I have gotten somewhat of a sense of what certain community members would like. I've also talked personally with people I know and are friends with around who live right around the borders of it, and they allowed me into their backyards to actually go hike around the area and see it for myself. So that's what I'm basing my testimony on.
And what is your sense of what you've gathered from your interaction or outreach with the community, just as a legislator?
I'm not sure I completely understand what you want, what information you want from me.
Yeah,
Or
I'm
what-
just trying to find out, I mean, are you able to comment how the community feels about this project? Because for me personally, I'm hearing all sorts of different things depending on who the proponents or the opponents are. And I think you're kind of a neutral person.
Yeah, you know, in the surrounding area, and I always like to take the surrounding communities area a little, their opinions with a little more weight because it directly affects them. You know, someone who's living in Olomana shouldn't necessarily be able to weigh in on what's happening in someone else's backyard. I mean, they can have an opinion and they're completely welcome to that, but it's just, I don't weigh it as heavily. In the surrounding area, I would say that there are a significant number of residents that care very much or are very much opposed to the expansion for one reason or another. I mean, it could be view plane, it could be saving the forest, it could be the damselfly. There are a lot of issues out there that have been raised with my office. I would say that there's a significant other portion of the population who maybe hasn't even heard of it or has no opinion on it. It may not, and maybe they don't live right up against the mountainside and are not necessarily subject to these floods. So, you know, if it's not right in your face, sometimes people just kind of, it's someone else's problem. But a lot of the neighborhood can see the area. And I have received testimony from individuals living in Pohainani as well, who don't want the expansion. That being said, we need to weigh that against whether there's an actual need in the community for this expanded capacity for Hawaiian Memorial Park, which is why the first testifier, that was fascinating. I actually hadn't even thought about that or looked at it, but I did in the last 5 minutes go and look at Craigslist, and there are a significant number of plots out there. Some of them are doubles, so Craigslist, you can post whatever you want. So some of them are people posting more than once, or looks like maybe they didn't know how to post, so it's the same post just with no picture, with picture, that kind of thing. But if there is really capacity, I mean, I think that's worth at least looking into. If we really are running out of space at Hawaiian Memorial Park, I think there is an interest in the community to have more space, because people on the windward side like to stay on the windward side even after they're not alive anymore. But if there is a secondary market out there that is as vast as what we think, or as what the testifier claimed, then I think that's something that should be taken into consideration.
Okay, thank you very much, Representative, and thank you to your great-grandfather for the care he showed my grandparents. Thank you.
Appreciate that.
Commissioner Giovanni. No, Commissioner Axon.
Thank you, Mr. Chair. Good morning, Representative Matayoshi. On your testimony, I heard two concerns. And I don't know if you heard the prior expert testimonies about how to dispose those excess dirt. But my question mainly on your second concern about the drainage and the retention basin. I understand that there's some concerns on those, but if the petitioner make adjustment to alleviate your concern, and even if we even put it on the condition that they will do it, will you still be opposing the project?
If they were to recalculate the retention basin, I mean, it's kind of a long process, but if they do adequately protect the houses, then I have less of a problem with this. Whether it's needed now, though, is another good point that I thought was brought up. So whether we need to expand it, especially because I know me and a lot of my contemporaries, we don't want to be buried either. You know, we're really just a burn us and spread the ashes kind of thing. So I would hate to get rid of more conservation land if it's not needed and if there is adequate space. If there's not adequate space and there is the demand, then sure. I mean, yeah, if the houses are adequately protected. In fact, I want more than just save the amount of risk that's there right now. I would like them, because they're going to be developing this area and putting the houses at risk, I would like them to kind of assure us that the houses are not going to be flooded, and really calculate in the anticipated increase in rainfall that we're probably going to be experiencing through global warming. So as long as the houses are protected, again, that is my primary concern, is protecting the houses. So if they do a good job at protecting the houses, then they can prove through, science and engineering that the houses are adequately protected. then I have less of a problem with it. If the spaces aren't needed at all, though, I think that that's something we should really consider. We don't want to be just, tearing down conservation land with no purpose. If there's a purpose and there's a reason and it's going to protect the houses, fine. If the real impetus of the need for creating these new grave plots is not there, though, then that kind of undermines the entire purpose of expanding the border, in my opinion.
I'm pretty sure we're gonna have more discussions on those, but I didn't hear your answer whether you're gonna be still opposing the project if those are those concerns are being addressed. Will you be still opposing the project, or?
Like I said, my main concern is the houses. If they're going to protect the houses, I'm not going to oppose it on those grounds, on the engineering grounds. That new argument, though, really did ring pretty true with me. If there is no demand for the plots, then that is another concern for me. And it was not in my testimony. I mean, it was just brought up by the testifier. But to me, that was a pretty good point that I think that we should consider.
Okay, thank you, Representative Matayoshi. Thank you, Mr. Chair. That's all I
Thank you,
have.
Commissioner Axon. Commissioners, other questions for the witness? I have a couple of questions, Representative. Starting with the demand, have you closely followed our lengthy proceedings on this docket?
I have not. I'm actually back in my law firm right now too, so it's hard to juggle everything. But
yeah,
what did something happen that was of?
Well, so I just want you to be aware that both the intervener as well as the petitioner have provided expert witnesses addressing the topic that the first witness today spoke on, over whether or not there is sufficient demand on this. And so I do believe that there's a robust evidentiary record before us. And contentions on all sides, but a robust record and analyses. Regarding the safety to the homes, we don't know each other, but my background is in environmental policy and conservation, and I work in climate change issues, among other things. So you're 100% correct that we're going to experience more flooding in Hawaii, that while precipitation overall is going down, events are becoming more intense. So for many communities, including the communities represent, this is the case no matter what. There's places that haven't flooded before that may flood now because of simply environmental change. And then you layer in, okay, now you're changing a landscape. The question I have for you is, the standard that you suggested was that if the developer can assure that these homes will be safe. I think if they did nothing, there's no way they can assure the homes will be safe because of changing climate. And there's, I suppose, theoretically possible engineering designs that could do to 100%. Like, yes, we know that every drop will be caught or diverted, but we all know that the rain events get higher and higher and more intense, and that there's probably some level at which there's a trade-off between what you can engineer, what you could actually fund, and the amount of additional safety.
Completely understand. Yep.
So what do you think is, beyond what's in the law, a reasonable standard for this commission to consider, short of an absolute guarantee?
Yeah, and I don't expect, you're right, I don't expect them to give an absolute guarantee. I don't need them to build like a moat around the memorial park to make sure that not a single drop gets by. When I was talking to the surrounding residents, whoever developed that area put in a drainage canal that's now overgrown. I mean, I saw a full-on tree growing in that thing. So it's clearly not working anymore. And even when it was put in place, I mean, it was only really put in place for, I think, a 10-year flood, although Mr. Yoshimori can speak a little more to that. I would like protections put in place to at least guarantee that and again, I'm not an engineer, but I would like them to guarantee against.
Oh my goodness.
At least a 50 or 100-year flood.
50 or 100-year? Okay.
Yeah,
sorry, you froze,
again,
you froze
no
temporarily, Representative. You froze right on the punchline of
Okay.
your testimony. Sorry.
That's what always happens in the movies. So yeah, I think given that 100-year events, a 100-year event are happening more and more frequently now, I think it would be safe to say that if they provided that kind of degree of protection to the houses, I would certainly appreciate it. I know that there is very little to no protection for the houses right now. So if the plan is going to better protect the houses to a significant degree, I think that that would be what the commission should be looking for. That they're doing the work to also protect and contribute to the community around the site itself.
Thank you for that clarification of your testimony. I just want to make sure that you weren't saying that there had to be an absolute
I mean, 100% is never, that's impossible. So.
Okay, thank you. Is there anything further, commissioners? If not, thank you very much for taking the time to testify. We're more fun to hang out with than the majority caucus. I have no doubt.
Way more fun. Way more fun. Forget those guys.
Okay.
And thank you all for your work on this. I really appreciate that as well.
You're welcome. I'm going to admit you back to being an attendee.
Okay. Take care, everybody.
I'm now going to bring in Judy Lemus or Lemus. If you can turn on your audio and video. Good morning. I can see you.
Good morning, everyone.
Do you swear or affirm the testimony you're about to give us the truth?
Yes, I do.
Okay.
Thank you for the opportunity. Yes, thank you for the opportunity, everyone. My name is Judy Lemus. I'm a resident of Kaneohe. I've lived here since 2008. I live at 45-214 Puali Koa Place in Kaneohe. I am a marine biologist, and I am a former member of the Kaneohe Bay Regional Council. And I am testifying today just in sort of as a witness, I guess, to the Kaneohe Bay Master Plan, as it were. I served on the Kaneohe Bay Regional Council from 2014 to 2020. I just recently cycled off. And I want to make clear, I am a member of the University of Hawaii. I'm a faculty member there as a marine biologist, but I am not testifying on behalf of the university. I'm testifying as a private citizen. Okay, so my testimony really, the gist of this is that the proposed expansion that is on the table really runs counter to the general position and the recommendations of the Kaneohe Bay Master Plan. That master plan was written in 1992. And I fully acknowledge that it does need to be revised, and there are elements of it that are quite dated. However, the principles that were used in drafting that master plan remain an issue. The strong evidence assembled by the task force that created that master plan indicated that water and ecological quality in the bay has been deteriorating since the mid-1980s. And it continues to deteriorate. And I'd like to just read a couple of passages from the master plan that I think are relevant to this discussion. The task force that developed the Kaneohe Bay Master Plan took the following positions on land use issues. The first, protect natural streams and preserve existing stream water flows into Kaneohe Bay. Second, preserve in their natural state existing wetlands, natural riparian zones, and hillsides with slopes of 20% or more. Restrict development in the watershed in accordance with the Ko'olapoko Development Plan. Also, the conceptual solutions that the task force used for public open space and access regarding steep slopes was that areas in excess of 20% slope be designated as conservation district by the state, and that graded areas should be limited to ensure runoff is manageable. Second, that maintaining open space is critical to preserve both the permeability of the watershed, which can help offset the effects of urbanization and channelization, and the existing rural character of the bay. And then thirdly, the general recommendations overall, in their general recommendations, there were many recommendations for changing land use district designations for key areas of Kaneohe Bay, but they were always from urban to conservation and not reverse. And one of those areas included the Kaneohe Kaba Stream confluence area. The other point that I think I'd like to make is that
That's 3 minutes.
Oh, I'm sorry. Thank you very much for the time.
Okay, if you want a moment to conclude, to make a concluding statement.
Sure, I'll just say that the water quality issues, the statement in the plan indicates that the carrying capacity of the ecosystem for further urban development based on responses to specific parameters is unknown. Aggregate changes in reef community structure indicate that the ecosystem may be approaching its adaptive limits. The warning signals and the noted uncertainties necessitate conservative land use decisions. Future urbanization can be controlled, but existing urbanization can possibly be mitigated but not reversed. That's a direct quote from the plan. Thank you very much for your time, and I'm sorry I went over.
Oh, it's okay, thank you. You were very close. Questions for the witness, Mr. Tabata?
No questions.
Mr. Pang, I think you.
No questions.
Thank you.
No questions.
The interveners have no questions. Thank you.
Commissioners, Commissioner Okuda.
Thank you very much, Mr. Chair. Ms. Lemus, should I call you Ms. Lemus or Dr. Lemus?
It is Dr. Lemus, but I usually just go by Judy.
Okay, Judy, but your doctorate is in what area, if I may ask?
It is in marine biology.
Okay. You know, the petitioner in this case has submitted engineering and other expert testimony, which seems to argue that, number one, there would really not be harmful effects from the development. And in certain areas, the development may, in fact, because of certain things that their consultants or experts presented, there's a possibility that it may actually better water quality for a number of reasons. Have you looked at the specific consultant reports or expert reports submitted by the petitioner to on those issues?
I'm sorry to say that I have not, and I am not an engineer, and I don't have any sort of experience in that area, so I don't know that I could speak to that. I can say just from experience, I think, general experience, I think that we have seen over the years that urbanization, even though when there are engineered solutions to issues that propose that they would make things better, they often actually do not work the way that they were designed. That's all I can say about that, but I'm not an engineering expert.
Yeah, and having grown up on the windward side, I remember Kaneohe Bay a lot differently than it is now. But my question is, the type of urbanization that's being proposed, and I don't mean to, you know, overgeneralize it, but the cemetery is not a giant concrete pad, or the proposed development is not a giant concrete pad. It really is a controlled, I don't want to call it vegetation, but like a controlled lawn. The fact that that type of proposed development differs from, for example, urbanization that looks like Windward Mall, would that affect your professional judgment in any way about what the potential impacts are to Kaneohe Bay?
Thank you for that question. I fully admit that there is a difference between impermeable and permeable surfaces in development, and they do change, in my understanding, the impacts on water quality. And I do have a little bit of an understanding about development of impermeable surfaces from time that I spent in Southern California. However, one thing I think that I would say, and you already pointed it out, is that this is essentially a monoculture of turf grass, which is not unsimilar to golf courses in that they need to be maintained. They do actually increase runoff. I think that there's a good record for that in studies, and they are often fertilized to maintain, you know, the aesthetics of that. And one of the things that the Kaneohe Bay Master Plan did comment on in terms of development was golf courses. They didn't comment, it doesn't say anything about cemeteries in the master plan, but it does comment about golf courses. And in my personal opinion, I believe that those are very similar in the way that they are managed and their potential impacts.
Okay, and final question. In the documentation that you've personally seen regarding Kaneohe Bay, was there any evidence of the present configured Hawaiian Memorial Park, the present Hawaiian Memorial Park Cemetery, contributing in any negative way to water quality or the ecosystem in Kaneohe Bay?
I do not have any information to that effect. No, I'm not aware of that, other than I think it's the potential for it given the channelization of our streams. No, I think the Kaneohe Bay Master Plan, if I can just go back to that, was the caution there was the development and changing of slopes. And so I think that might be a difference in this expansion versus what was developed originally in the Hawaii Memorial Park.
Okay, thank you very much, Dr. Lemus. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioner Chang.
Thank you, Judy. I greatly appreciate you taking the time to be here this morning. I was just wondering, you were mentioning that, that this was inconsistent with the Ko'olapoko, or maybe let me ask you, do you know whether this plan is consistent with the Ko'olapoko Sustainable Community Plan?
That's an excellent question, and I have not looked at the Ko'olapoko Sustainable Development Plan in, I would say, recently, that I could answer that question with confidence.
Okay, thank you so much for your testimony today.
Thank you.
Thank you.
Commissioners, further questions for Dr. Lemus? What is the date of the most recent version of the Kaneohe Bay Master Plan?
It's 1992. It hasn't actually been revised since then. I want to say it was a May 1992.
The year is. I'm familiar with that version of the plan. I didn't know whether there was a more updated version of the
There
plan.
haven't been. It was discussed actually when I was on the council, and unfortunately the council had some interruptions due to lack of representation on it, and so, but I believe that it is actually on the docket again for them to revisit that for updating.
Okay. Do you know if the plan talked about beyond land use controls by government? Did the Kaneohe Bay Regional or Master Plan talk about the use of conservation easements at all?
I believe that there is something in there about some conservation easements, maybe relevant to northern parts of the bay. I don't recall it being discussed in the southern parts of the bay, but I'd be happy to look if you'd like me to.
Just, are you familiar with the proposal in front of us in exchange for a partial urbanization and absolutely changing into the urban district and changing of steep slopes, that there's a permanent easement put on the remainder of the property? Are you familiar with that provision?
I am familiar with that provision. Mm-hmm.
Okay.
Yeah, I think it's, and I think that that's an excellent element of that provision, but I also would just say that the grading of the slope is still, I think, of concern.
Great. Thank you very much for your testimony today.
Thanks very much.
We really appreciate it. I'm going to move you back into being an attendee.
Aloha.
Aloha. I'm going to admit the last person who raised their hand, Wilfred Chang. And after that, we will take a break. When you're admitted to the meeting, please enable your audio and video.
Morning.
Aloha. Do you swear or affirm the testimony you're about to give is the truth?
Yes, I do.
Okay. Please state your name and address for the record, and you have 3 minutes.
My name is Wilfred Chang. My address, I'll use my business address. It's 451 Atkinson Drive. I'm an international IOW international representative for Hawaii. The reason why I am testifying is because I was asked on behalf of our membership who make up the grounds crew at Hawaii Memorial, as well as our membership in the residing areas of Kaneohe. We do have longshore, we do have people that work in warehousing and trucking and hospitality and hospitals that reside in Kaneohe. So I'm taking this opportunity to provide support for this amendment that's being asked by Hawaii Memorial. Hawaii Memorial has been a union house since, I believe, the late 60s, early 70s. They've been in existence for over 50 years. I've wanted to take this opportunity to speak on the company as what it provides for the community as far as the workforce and our membership. I don't know if you guys realize, but 100% of the workforce is local. They come from Kaneohe as far as Waimanalo, Kalu, in the Kolaupoko area. What's of concern to me, and again, please forgive me, I'm not from that area, I'm from Pro City. However, the community has led strong support in this project. I don't understand why the company is being vilified. They've been going above and beyond, and I'm not going to get into the specifics about the dynamics about science. We'll leave that to the professionals. I'm sure they did their due diligence. But what I will speak on is the ability for our membership to provide for their families, for their future, right? Past, present, and future. We've had 2 members recently retired. They've been there for 50 years. They were able to provide a great living for their families. So in short, we are in support of this project. Please give strong consideration to this project. And, we're open to any questions.
Thank you for your testimony. Petitioner, questions for the witness?
No questions.
No questions from the city. Thank you.
No questions.
Interveners have no questions. Thank you.
Thank you.
Commissioners? Any questions for Mr. Chang? If not, thank you very much for your testimony today. We appreciate it.
Appreciate it. Thank you.
Okay. I'm going to move Mr. Chang to be an attendee. Is there anybody remaining in the attendee, as an attendee to this meeting, who wishes to testify in this matter? Raise your hand now using the raise your hand function. Seeing none, I'm going to close public testimony in this matter, call for a 10-minute break till 10:23, and we will start with the closing arguments of the petitioner. We're in recess. Great. We are ready and on video, and looks like some of us are caffeinated. So we're back on the record. It's 10:23 a.m. Before Mr. Tabata, you proceed with your closing argument, can you give me an overview, and then I'll ask all of the parties to give an overview of how many minutes you think you need for your closing argument, absent questions?
I'm shooting for 10 minutes.
Okay. City.
City, very briefly, 3 to 5 minutes.
Okay. 2 hours, Ms. Apuna?
2 minutes. 2 minutes, please.
Mr. Yoshimori.
Interveners estimate 14 minutes.
Not 13 and a half. 14. Okay. This sounds good. Great. Thank you for that heads up. We'll see how far we can get before our next break. Mr. Tabata.
Thank you, Chair.
You're welcome.
Hawaiian Memorial is requesting approval of its petition for district boundary amendment for the reclassification of approximately 53.449 acres to the urban district. If Hawaiian Memorial's petition is approved, Hawaiian Memorial will proceed with the expansion of the existing cemetery, the creation of a cultural preserve, the execution of a conservation easement, the construction of drainage improvements, a protection plan for the black line Hawaiian damselfly, as well as the continued future cemetery operations that will be made possible with the expansion. The cemetery expansion will add 27.5 acres of new cemetery lands for future interments, including burials and cremation interments. The expansion will result in approximately 30,000 new burials that will allow Hawaiian Memorial to care for our family's needs well into the future. More opportunities will be created to provide families with the option of being interred together in Kaneohe. In addition to traditional burials, cremation options will be available, including cremation gardens, like the one we viewed at Ocean View Garden during the LUC site visit. The expanded cemetery will, like the existing cemetery, be covered by an endowment care fund that will ensure the future maintenance of the cemetery in perpetuity. The 14.5 acre cultural preserve would facilitate the restoration and management of Kavaivai Heiau, and access to the cultural preserve would be provided through the main entrance of Hawaiian Memorial Park to allow cultural practitioners and kumuhula to continue their practice of gathering plants and care for the resources for cultural practices. The cultural preserve will also allow for traditional cultural practices, including burial practices in the preserve. And this is an express wish by the Hawaiian practitioners. Management of the cultural preserve by the Ko'olaupoko Hawaiian Civic Club will address issues relating to cultural practices, access, maintenance, education, and the management of areas subject to rockfall. The conservation easement would cover approximately 156.5 acres of land and would include the cemetery expansion area, the cultural preserve, as well as 114 additional acres of Hawaiian Memorial's parcel. The conservation easement would guarantee in perpetuity that the land will not be developed for any other purpose. The prohibitions in the conservation easement would constitute a relinquishment of any existing or potential development rights other than the cemetery expansion. So even though certain development may be allowed on conservation district land, the conservation easement would prohibit any future development and preserve the land in its natural state. The project will include drainage improvements that will reduce the stormwater runoff by 4% and runoff volume by 5%. This reduction will be achieved by decreasing the slope of the land and improving the permeability of the soil, resulting in more water being kept on the property. Drainage improvements will include detention basins and vegetative buffers. The basins will be built with 12,700 cubic feet of capacity, and vegetative buffers will be placed between the expanded cemetery and lower lying areas. Best management practices, or BMPs, will be used during construction to mitigate against runoff, and as required by the city rules, construction will only be allowed to proceed in 5-acre increments to minimize the area of exposed earth at any given time during construction. We have provided the Commission with our preliminary engineering report, which describes our proposed drainage improvements. If our project is approved, a grading permit will be required along with more detailed engineering. The city's drainage rules, which have the force and effect of law, will be applied and enforced by the Department of Planning and Permitting Civil Engineering Branch. Protection of the black-line Hawaiian damselfly is also a part of the Hawaiian Memorial Project. The proposed project will allow Hawaiian Memorial to install improvements to ensure the survival of the damselfly by installing a water line to guarantee water flow into the seep, installing herringbone subsurface drains to aid in water flow, the building of fences to keep out wild pigs, placing small sticks at the water's edge to help the young damselfly avoid predators, and monitoring to keep out invasive species, watch the water flow, and manage the area. These protections will give the damselflies a better chance at survival in light of drought, trespassers, pigs, ants, and invasive species like mosquito fish. Hawaiian Memorial has been operating as a cemetery since 1958. It has, throughout the years, cared for our families and neighbors, and the petitioner has been and is the employer to over 200 individuals. Petitioner's parent company, Service Corporation International, or SCI, is a publicly traded corporation that will contribute the $30 million in development costs if this project is approved. If the project is approved, our market study forecasts absorption of the expanded cemetery in approximately 23 years. That's 23 years of families caring for their loved ones and 23 additional years of continued employment. The cemetery will one day become full and further expansion will not be possible. But that day need not be today. When that day arrives, we can take comfort in knowing that the financial strength of SCI, with the fact that Hawaiian Memorial is an endowment care fund cemetery, will ensure that our interments will be maintained and cared for in perpetuity with trust monies dedicated solely for that purpose. We have all seen disturbing images on TV of neglected or vandalized graves, together with distraught family members. That, unfortunately, can be the result of cemeteries that are not endowment care fund cemeteries. When petitioners come before this commission to ask for approval, it can be a challenge to know whether the proposed project is viable. As regulators, planners, and lawyers, we tend to get jaded and view projects with skepticism. But Hawaiian Memorial Cemetery expansion project is not speculative. Hawaiian Memorial is a proven, long-standing business and an established employer. Hawaiian Memorial is not proposing a new or controversial use. The project is a continuation of a 60-year-old cemetery, and according to public testifier John Puchalski, Kaneohe Town was built around Hawaiian Memorial Park Cemetery. Other public testimony in support of the project included Gold Star families, Kaneohe residents, labor unions, people with relatives interred at Hawaiian Memorial, and members of the Ko'olaupoko Hawaiian community. This cross-section of our island shows us that Hawaiian Memorial has earned its place in our community. Finally, we would like to thank the commission, its staff, and the parties for everyone's hard work. The COVID-19 pandemic has forced us to accept disruptions or make adjustments. And so it is notable that the Land Use Commission has been able to transition to continue to do business. The docket on this petition has been ongoing for about 1 year. And for some of us, it's been anywhere from 4 to 10 years of laying the groundwork to bring this petition for district boundary amendment before this commission. The vast majority of proposed projects never get this far. Most projects fail in the early stages for various reasons, including infrastructure costs, land acquisition issues, lack of financing, the need for community plan amendment, the need for an EIS, the lack of public support, or simply the inability to accept a process that can sometimes require a decade to complete. There are dozens of pieces that need to come together before a project can be brought before the Land Use Commission. There are many supporters, friends, colleagues, and employees to be thanked, without whom we would not be able to make this request. We would especially like to thank the Department of Planning and Permitting and the Office of Planning for helping shape the project with their comments and issues, and for their support of our project once we had addressed their issues. It should be acknowledged that OP and DPP have the difficult job of coordinating the review of state and county agencies, as well as representing the agencies' issues and concerns, which are in addition to their own. Therefore, petitioner Hawaiian Memorial Park Limited respectfully requests that this honorable commission approve its request to reclassify approximately 53.449 acres of land to the urban district. If there are any questions, we will be happy to try to answer them. Thank you all very much.
Thank you, Mr. Tabata. Our first questions will come from Commissioner Giovanni, followed by Commissioner Okuda.
Thank you, Chair. Thank you, Mr. Tabata. Mr. Tabata, are you familiar or do you recall the expert witness testimony provided by the intervener regarding the meteorological events that might be forthcoming as a consequence of climate change?
Yes, Dr. Bussinger.
Is it fair to characterize that testimony as an indication that both 24-hour storms and the 100-year storms will be more violent and more frequent in the future?
I believe there was no evidence contradicting Dr. Bussinger.
Is that a yes?
That's a yes.
Thank you. Are you also familiar with the expert testimony by the intervener that suggested that using the city and county's standards for sizing of the retention basins based on the 94-acre parcel study were insufficient, and they were suggesting that they might be undersized by a factor of 5 to 10-fold?
I recalled John Hyam, their engineer. He testified that the basins, he believed the basins should be expanded by 5 times. And he came up with a number, I guess our basins are sized at 12,700 cubic feet. So 5 times of that, according to Mr. Hyam, our basin should be 63,500 cubic feet.
So in general, I don't want to get into the specific sizing, but the testimony suggested a more stringent standard be applied as compared to the one that was recognized by your preliminary civil engineering work. And that would result in a larger retention basin. Do you recall that general testimony? I think he was referring to something called the Plate 6 methodology, which was more stringent than what was being suggested.
Right.
Petitioner.
Right. John Hyam's testimony, as well as Jamie Hirota's testimony, I think they both acknowledged that the use of Plate 6 would be required if we had over 100 acres of drainage area, which we do not. We're about 93 acres. So according to the rules, we are properly using the rational method, but nevertheless, John Hyam's testimony is clear. He believes it should be 5 times bigger, a basins, that is.
That's correct. I agree with your recollection. Do you also recall the exchange between Mr. Matsubara and myself on this topic?
I believe so. I believe that was towards the end of the proceeding, something to do with condition, I think.
Yeah, I asked if the petitioner would, in his judgment, would accept a more stringent condition to use the Plate 6 methodology as opposed to the rational methodology. And my characterization, and I'll say it, and you can either agree with it or dispute it, was that Mr. Matsubara said that they would comply with the rational method, and that if it was imposed by a condition of this land use commission, that may or may not, we may or may not have the authority to do that, and that might be subject to even being challenged at the Supreme Court. And to avoid that contingency, one way to avoid that would be if the petitioner voluntarily agreed to use the more stringent Plate 6 methodology, which would result in larger retention volumes. You recall that exchange?
Yes, I do. And Mr. Matsubara was correct in that the use of the condition would need to be based on the law, and that we would follow the law. And it's also correct, however, that if we agree to a condition, then that can serve as the basis for applying it and enforcing it. So yes, if we agree to the condition, then it can be applied. I agree.
So are you willing to agree to a condition such as that, the more stringent methodology for sizing the retention ponds?
You know, we would certainly appreciate having the opportunity to consider it. You know, if you're looking for us to expand it to a certain size, we need to, if we agree to it, we need to make sure that we can comply with it. And we would like some time, you know, to talk to our civil engineer, if possible, short recess, and get back to you, shortly.
You remember the conversation between Mr. Matsubara and I when he said that my questioning was putting him in the proverbial position between a rock and a hard place?
Yeah, we're trying to get out of that place right now.
Is it clear that the location to get out of that position was to voluntarily agree to a more stringent methodology for sizing the retention ponds?
Absolutely. We would like to agree to that. However, we would like to have a number, if it's 63,500 or what, and have a chance to speak with our engineer. I think it's reasonable. If you can give us 10 minutes or 15 minutes, we just want to make sure we can comply with that large basin.
Chair, I'm willing to afford the time. I think this is a critical issue which will affect my vote on this petition, and I'd like to hear back if 10 minutes is sufficient. I don't know if it is, but to me, in the absence of a hard and firm commitment by the petitioner, it will affect my position on this docket.
Commission, my inclination is that, that the petitioner could have anticipated this line of questioning, but that I'm willing to give 10 more minutes and go into a 10-minute recess immediately for them to consult and come back with a response and then continue with our questioning. Is that acceptable, commissioners?
Sure. Thank you, Chair.
Okay, we're in a 10-minute recess till 10:52. Okay. Let's go back on the record. It is 10:51 a.m. You had 9 minutes, Mr. Tabata. Can you respond to Mr. Giovanni's question, and then he'll be allowed to continue questioning?
Yes, thank you. Okay, we got to speak with our engineer, and we believe, we can construct the basins to capacity of the 63,500 that John Hyam recommends. So if we're given a condition that requires us to build our detention basins to 63,500, if we're offered that, I believe we can accept it and comply with it.
Well, I think I don't think we have enough specific information on record to just adopt a specific number, but I think we could agree to accept the more stringent methodology to be used that may produce a number such as that, which would be the normal course for the process. The number that comes out of a plate 6 analysis for a 100-acre plus excavation may result in 63,000 or more than 63,000 or less than 63,000. I've not done that analysis, and I've not seen any evidence to support that number specifically, other than the conjecture of the expert testimony that was provided by the intervener. So with that, are you saying you are willing to accept and utilize the more stringent plate 6 methodology to determine the appropriate and adequate size of the retention basins?
Okay, what I'm told is that if we go with plate 6, it may not result in any larger detention basins. Okay.
Not, no, but that's the more stringent.
What I'm told is it's going to affect the entire drainage system. It's going to require us to enlarge in the pipes, okay, to deal with a higher flow of plate 6, and then send it to the city's drainage facility, and then let them deal with it. That's what I'm told. Okay, so I mean, if we want to enlarge our drainage basins, this is the opportunity to require us to enlarge in them according to the intervener's own expert witness. I don't know, we don't know what the drainage system will look like if the only metric we're forced to comply with is plate 6. It's not just, it won't just affect the basins, it's the entire system.
As maybe it should.
and it may not affect the.
You heard the testimony today from Representative Matayoshi. This is the #1 issue that he felt compelled him to come provide public testimony today. It's very unfortunate that the topography of that land funnels the drainage directly in the backyards of homes that are already built right below where this project would occur. So it does require special and adequate and stringent attention to this detail. I know it's costly, but it's the only thing that's that in my view must be addressed in an adequate fashion to assure the safety of the people living below the project.
First of all, Commissioner, I'm not arguing with you. I want to get to the same place we're getting, which is to decrease as much as possible the flow of water. Okay, but the drainage rules are set up so that we do not increase the flow. That is the standard. Okay, so, and the problem with plate 6 is that there is no way to judge or to measure post-development. So if we use plate 6, we're going to have the same number, 1,000 cubic feet per second before development and after development. So we don't know how it's going to affect any decrease in runoff. That's what the rules say. That's the standard by which this commission has always faced drainage issues. We're required to not increase the drainage flow. That's why our basins may not increase. But because we have to deal with more water, our pipes will increase in size and transfer more water downstream to the city's facilities, which are in the residential neighborhood. Okay, so if our goal is to keep as much water on our property as possible so that we do not send it downstream, the only thing we can see is dealing with John Hyam's testimony, his recommendation to increase the basins 5 times as big. That's the only way I see we get to that endpoint.
So let's go a different direction, Mr. Tabata, or along the lines you suggest. I don't have his testimony in front of me, but I believe he was speculating to a range, not to just merely a 5x value. I think it was like 5x to 10x or something to that effect. Is that your recall as well?
No, it's July 22, page 143 of the transcript.
Would you, if you have that available, could you read it for the benefit of the commission?
Let me bring it up.
Thank you.
If I may screen, I can share this.
Yes, please, you're allowed.
Thank you very much. Okay, this is page 143 of the testimony taken on July 22, John Hyam's testimony, and it starts at line 7. I think they should be required to increase the size of their anticipated 12,700 cubic feet permanent basins by 5 times to an actual minimum of 63,500 cubic feet. That's what we were working on, we're looking at. And that's the number we just spoke with our engineer about to see if we can actually build that. And we think we can do it.
Okay, thank you. I'm going to give back my time now. So thank you, Chair. Thank you, Mr. Tabata.
Thank you, Commissioner.
Thank you, Commissioner Giovanni. Commissioner Okuda, followed by Commissioners Chang and Cabral. Commissioner Okuda, do you have a sense of the amount of time that you would like to spend?
Yes, less than 5 minutes. I know it will shock everyone, but just less than 5 minutes.
There was no judgment, just trying to manage the flow of the meeting.
I understand, Mr. Chair.
Please proceed.
Thank you. Mr. Tabata, and I thank Commissioner Giovanni for those questions. That limits my questions just to 5 minutes or less. Let me assure you, Mr. Tabata, and to you, to Mr. Matsubara, I haven't made up my mind at all. And so please don't take my next question as indicating anything like that. Now, if this petition is denied, it will have, it would not be a reflection on the quality of legal representation by you and Mr. Matsubara, because at least for me, publicly and privately, I hold you folks in high esteem. Your word can be trusted. But this is my question. I understand that clients can fire or terminate their attorneys at any time. But if the petition is granted with or without conditions, part of the fact that the petition is granted very well may be on the fact that I or other commissioners or many commissioners trust you, Mr. Tabata, and Mr. Matsubara. So let me ask you this. When this Land Use Commission proceeding is completed, do you still intend to represent Hawaiian Memorial Park and SCI as going forward regarding this matter? Or is it the present intention that your representation ends with this Land Use Commission action?
Well, if this client will have us, we will continue doing work. And I will say this also, that the fact that Jay Morford is the president of Hawaiian Memorial plays a tremendous part in whether or not Ben and I continue working and representing them.
Do you or Mr. Matsubara have any present intention not to continue representing Hawaiian Memorial Park with respect to this matter?
No, sir, we fully intend to continue representing them if they will have us.
And that would be at least in the foreseeable future to the completion of all representations, whenever that may be. Hopefully it's before we're dead.
Yes, Commissioner, hopefully before that.
Thank you, Mr. Chair. I have no further questions.
Thank you, Commissioner Okuda. Commissioner Chang.
Thank you very much, Mr. Chair. And thank you, Mr. Tabata. I just have several questions. I wanted to follow up on Commissioner Giovanni's question. As I recall Mr. Hyam's testimony, he did propose as remedies, one, to move to a larger retention basin, and two, the Area D create greater mitigation behind the three neighbors outlets. Is that something that you would also consider?
But we would definitely want to do whatever we can. The neighbors outlets, I believe that's a city and county facility. We do not own them. You know, even if, you know, I'm sure Hawaiian Memorial will be willing to do the work, but it's you know, getting access to it, getting permission. I mean, that's out of our control.
And I guess I understand. It's very obvious. Mr. Yoshimura, the interveners, they have been committed to this project and to raising their concerns. And quite frankly, I think Mr. Yoshimura has been quite effective as a pro se. Will Hawaiian Memorial Park commit to continue working with these neighbors? And I know that's just words, but you know, truly engaging with them to address their concerns, especially in relationship to the runoff and the drainage.
Absolutely. Hawaiian Memorial has never refused to have discussion, consultation with anyone. So yes, answer is yes. They will be. Yes.
All right. And I want to, you know, and what I'm hoping that it amounts to is more than just discussions, but a genuine engagement where you can find some mutual grounds to reach some kind of an amicable remedy to some of their concerns. So, and as Commissioner Okuda acknowledged that you will continue to serve as long as Mr. Morford or Hawaii Memorial will have you, I too trust that you will ensure that happens. My other questions relate to a lot of your testimony was if the petition is approved, then Hawaii Memorial Park will do the following. So with respect to the damselfly habitat, and I too, like Commissioner Okuda, I have not made up my mind, but if it is not approved, will Hawaii Memorial Park make a commitment as the owners of that land who now have knowledge of this habitat to take appropriate measures to protect that habitat?
Well, we are on notice. We have made sure we do not disturb the area. There's been our expert Steve Montgomery, when he heard about the damselflies, he went down and he found that someone had placed branches and rubbish around the seat or on the seat, and he had to clear it out. Okay, so I mean, there have been measures taken to do what we can to protect the seat. The problem with having us do something like agree to all the protections that we propose is that it's labor intensive. There's costs involved. So that's why the granting of this petition and of a project is critical in order for us to conduct all of those protections that we're proposing.
And Mr. Tabata, I'm not suggesting that Hawaii Memorial Park would be required to put in the herringbone and all those other measures, but it's more because you had heard concerns by the commissions about there's really no law that enforces just passive neglect, doing nothing. But Hawaii Memorial Park is now on notice that there is this critical habitat. So if it's more than just Mr. Montgomery, but part of Hawaii Memorial Park's maintenance crew that does monitor that site regularly to ensure that, in consultation with DOFA, that there are measures to protect that habitat that doesn't require a lot of cost, but just maintenance. Is that something that Hawaii Memorial Park will do?
Yes. Hawaii Memorial Park will continue to be a steward of its lands, do whatever it can within reason to protect the damselflies, as well as the cultural resources like the heiau. They'll do whatever they can. They will, even if the commission were to deny our project, we will continue, to do what we can to protect the resources on the land. Yes.
No, thank you. And that was the other question regarding the heiau. I mean, obviously, Hawaii Memorial Park has developed a relationship with the Ko'olapoko Hawaiian Civic Club. They have had work days and they have expressed an interest in also working collaboratively to steward that heiau. So these are cultural and natural resources that the landowner may not be required to do anything, but now they're on notice and again, I'm not saying that he hasn't done anything or they haven't done anything for the heiau, but I would, my questions are more in line of stewardship. So if it's not granted, they will continue to steward those resources, whether independent of the approval or disapproval of the boundary amendment.
That's correct. We are members of this community. We will do like we've always done and work with our neighbors in our community and take care of our resources.
And I appreciate that because they have demonstrated that their past behavior. I just want to make sure that that continues on and that there's a record to that. And then does the petitioner have any objections to Office of Planning or Department of or DPP's additional recommendations?
No, I mean, all of their proposed conditions,
Yes.
we've agreed to them, I believe.
Okay. Okay. I just wanted to get that for the record. Thank you very much, Mr. Tabata. I have no other questions.
Thank you.
Thank you very much, Commissioner Chang. Commissioner Cabral, followed by Commissioner Giovanni.
Thank you, Chair and Mr. Tabata. I guess my question goes back to Commissioner Giovanni's concerns about the differences in retention and detention basins, and to make sure that we really are going to do adequate holding of the water, I think, to make sure that we do better. I'm trying to review all my notes from all these different hearings, and I understand, because I do live in a flood zone myself, that it can happen, and naturally it's happening already now, or it could happen in an increased manner with increased rainfall. But my point of if this petition goes through, I would like to think that the efforts made by Hawaii Memorial would help to control that and to help protect and prevent flooding of the properties below. So I just want to, I had a question, but you've already answered it with to Commissioner Giovanni's information, but I wanted to just reiterate that the concern I have is that we really do above and beyond what nature is doing right now in regards to the potential flood for the areas below. That would be my only comment. Thank you.
Thank you. We agree. And we think the best way to achieve that decrease is to keep the water on the property, which is through the basins. Thank you.
Anything further, Commissioner Cabral? You're muted.
Yes, thank you. Sorry, no, thank you. The information we got for Commissioner Giovanni answered a lot of my questions, because I do have my own scribbled notes here about 12,700 times 5 equals 62,500 cubic feet was the proposal then, and I can somewhat like the idea that you would try and hold it on your property better than just constantly flooding the city and county pipes below, because I can't imagine that they're going to be able to contain what they already are being fed, plus this massive amount of water on a continuous basis. So I think greater retention basins on the property might be a really good attempt to control flooding. Thank you.
Thank you, Commissioner Giovanni.
Thank you, Chair. I want to shift gears, Mr. Tabata, and state that I was very pleased to see in your proposed order a condition in which the petitioner would not dispose of any materials at the PVT landfill. So thank you for that. However, I think that condition might be a bit narrow, and I'd like to explore that. Are you familiar that PVT is currently the only construction and demolition landfill on Oahu?
Yes.
Are you also aware that last week they announced that they will not seek an expansion of that facility?
I remember some announcement, yes.
It was published in the Star Advertiser, among other places. So basically what that means is that Oahu is going to be in search of a new facility somewhere, somehow, somewhere, because we cannot have any assurance that the PVT landfill will serve the community's needs indefinitely. And they've, by virtue of them announcing that they're not going to expand that facility, the possibility exists that there will be another one in our future sooner or later. So would you be agreeable to modification of that condition to make it more generic, in such that your project will not dispose of any materials in a construction and demolition landfill on Oahu, period.
Yeah, we understand the concern. There is on the horizon a limited life for PVT. If possible, though, we would like to make use of that capacity if necessary, even as a last resort, just so that we are treated the same as everybody else on this island. But we would be willing to accept a restriction that we look for other alternatives first, and that be our last alternative for any materials other than the soils that we pointed out. It's it's a practical consideration, and it's something that it would tremendously important to us. We have that ability.
So Mr. DePata, I want to make sure you're not going backwards on us here. So are you talking about, first of all, let me clarify. So what is your commitment and your willingness in terms of accepting an order, a condition on the order not to dispose of materials at the PVT construction and demolition landfill?
Well,
is it limited to you're agreeing only not to put soil there, or more than that? Or are you still looking at possibly putting soil there as a last resort?
No soils, no clean soils, no clean fill will be sent to PVT. That's something that we are firm on, as our proposed condition states. No excess fill, no soil, no excess soil. But when we say any materials, any construction debris, that's different.
That's different. I agree. So I might have confused the issue. I'm asking, what I really want to ask you, are you willing to agree not to dispose of any soils or clean fill at any C&D landfill that is commercially in operation on Oahu?
Yes. Yes, we can. That sounds like our proposed condition. It could be modified to say PVT or any other
commercial C&D landfill.
Any other, right, C&D construction debris landfill, correct.
I'm agreeable with that. Thank you, sir.
Thank you.
Commissioner Wong, followed by Commissioner Okuda.
Thank you, Chair. Thank you, Mr. Tabata. So when I reviewed your conclusions of law, findings of facts, and decision orders, 150 something odd pages, it looks like you're amenable to a lot of things. And also, I just wanted to reaffirm Mr. Giovanni's line of questioning when he first talked about the water basins. So you're amenable to increasing the size of the basins by 5 times?
Yes, that's correct.
That's one line of questioning. Then the other thing I just wanted to reaffirm, because I know like any construction projects, sometimes you have non-soil materials and you cannot, the soil materials, you're going to try and look for it and repurpose it and reuse it at other sites. I think Lance said that in one of your expert witness, correct?
That's correct.
Yeah, just because I guess you can always sell that soil for other projects. The contractor can do that. So you're going to try your darndest to recycle and reuse whatever you can. And that PVT would be the last resort, correct?
I believe what we said in response to Commissioner Giovanni is that we will not send any clean soils to PVT or any other C&D landfill on this island. We will not.
Okay.
That's a firm commitment.
Yeah. And so the other line of questioning I have is that we had a witness just today was talking about the Kaneohe Bay issue. I think she was a doctor in marine biology. So can you explain to me if there is any soil runoff or water runoff, how would that water get into the Kaneohe Bay?
The drainage flow in our area goes down into the neighborhood outlets,
Okay.
the county outlets, and from there it flows to Kava Stream and then to Cape Bay.
Okay, but with the drainage basins increase, hopefully nothing will go into KB, correct?
Right. With the best management practices that we have proposed during construction, we'll minimize runoff, and the basins, correct, will be there to hold the water and to hold the sediment to runoff. And after construction, the turf grass will help to basically clean up the runoff. That was the conclusion of our expert.
Okay, and I guess when you were doing your closing statements, you said that I'm going to the damselfly now, and about their little area, their habitat. So you said even now, someone from the Memorial Park does go and clean out sticks and debris, and they'll try to be as good neighbor as possible in trying to keep that area clean, correct?
That was our expert,
Yeah.
Steve Montgomery. He went down and took a look at the property, and he saw branches
right
placed in or around the seep, and he cleaned it up to benefit the seep. We do not have a regularly scheduled program in place. We have not. That's manpower that we have not allocated yet.
Okay. So what I'm getting at is, I guess in our time period of going through this whole process, it appears that Hawaiian Memorial do not need to do anything if let's say we don't give you this change. They can just leave it as is, and if it dries up, it dries up, and the dragonflies goes kaput, correct? I mean, there's no obligation.
Damselfly.
Yeah, of the damselfly. Thank you. Is that correct, Mr. Tabata?
Unfortunately, yes. That's
okay. However, in the DNO, the Hawaiian Memorial Park will do all in its darndest, it seems like, to keep the damselfly alive. Is that correct? And populate.
Correct. Those were the recommendations of our expert, Steve Montgomery.
Okay, that's it. Thank you, Mr. Tabata. Thank you, Chair.
Thank you very much, Commissioner Wong. Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Tabata, this is a follow-up to Commissioner Giovanni's last question regarding PVT or a similar type of construction, demolition, disposal facility. As far as the applicant or petitioner's representation that it will not dispose of clean fill, what about rocks or boulders or items like that? Is the representation that type of materials from the excavation will or will not be disposed of either at PVT or a similar type of construction debris landfill?
What we plan on doing is minimizing as much as possible any use of landfill, of anything that's going to cost us money to dispose of. Whether or not that it becomes necessary to try and use PVT, that's an option that we want to keep available. We're not talking about the clean fill. We want to make clear again that we're certain, we're making a commitment not to put clean fill, clean soils in PVT or any other CD landfill. But other construction debris, you know, if PVT is still open, if they still have capacity, we would like to have that option, like everybody else.
Okay, well, so in other words, clean fill does not mean boulders or material like that. Is that correct?
I don't, that's correct. I don't believe it is.
The amount that's estimated as far as what is going to be excavated from the Oniava Hills in these, in some places, 100-foot high cuts. The estimate was about 457,000 cubic yards of material, correct?
I believe that's correct, yes.
What evidence in the record indicates how much of that material will be clean fill?
My understanding is all of it was clean fill. That was the soils being excavated.
Well, there's going to be cuts made into the Oniava Hills, correct?
That's correct.
Where, can you point where in the evidence there is any statement that all of the excavation into the Oniava Hills, that all of the 457,000 cubic yards of material are all clean fill?
I don't think there's any specific information of that. It's just that when the numbers were calculated, that it was the soils that were being calculated. I don't think we know how much there's going to be in boulders. Boulders probably aren't even visible. I don't think we know that yet.
Yeah, and of course, even in the expansion area, your engineer concluded there was risk of boulder falls or rock fall, which means there must be rocks in the area to fall, right? Because if it was all clean fill, we wouldn't have any risk of boulders coming down, correct?
That would be reasonable.
Okay, and following up on Commissioner Giovanni's question about the withdrawal of PVT of its request for expansion, which you talked about, are you aware the governor signed Senate Bill 2386, Senate Draft 2, House Draft 2, which is now the law which requires a half-mile buffer, I believe, around landfills?
I'm generally familiar. I haven't gone through it in detail.
Well, whatever your familiarity is, doesn't that bill or the signing of that bill into law more likely than not make it more difficult to establish an additional construction debris a landfill or a landfill for construction debris? The half-mile buffer around any such facility makes it more difficult than less difficult to establish such a disposal site.
Well, the way you describe it, it's definitely an added challenge to building projects. And we don't dispute that in the future they may simply not be available. It's just what we would like to avoid is to accept another condition that would take away our ability to do business like everybody else on this island. If it's gone, if it's not available, then so be it. That's something we'll have to deal with. We're just concerned that if we are required or if we're asked to accept more restrictions that hamper us, that tie our hands even more than every other person on this island doing business. That's a concern. We just want to be able to do business like everybody else.
Of course, but not everybody else right now is proposing an excavation of that many cubic yards, which may have boulders which have to be disposed of, correct?
That's correct. And if there's no more capacity, then we will do what we need to do. No doubt, we will crush the boulders. We will do whatever we need to do. It's just that we don't want to be restricted. If it's available, then it's an option. We'd like it to be an option, but if we, if it closes and it cannot, they have no more capacity, we will do what we need to do to deal with the boulders. We will.
Hey, my final question is this. Should the Land Use Commission be concerned about preserving capacity at the PVT landfill so that the many other ongoing construction projects which employ many other workers in the community, so that these projects are not impacted? Is that a concern that we on the commission should have, that we need to look at preserving capacity for other projects?
No, I think that there are various projects that may or may not be built on this island. Some may be in the approval process, and there's no way for something like this to be applied to everybody. Even including others who are seeking approvals from other administrative bodies right now, including yourself. So. What we're asking is for a fair opportunity to compete, basically, with everybody else.
Okay, thank you very much, Mr. Tabata. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Before I recognize Commissioner Giovanni, I'm going to note that there's a hand up in the attendee section. I'm going to lower the hands that are up. It might be inadvertent, but if somebody was trying to say something, public testimony was closed on this matter. So it's the equivalent of if we were in our physical setting and somebody stood up in the audience and said, hey, I want to say something, we wouldn't allow that to occur right now either. If you have a procedural question about how things are going, you can put something into the Q&A box. And if it's a procedural question about what's happening, the staff will try to answer it. If it's testimony, that's been closed off. Commissioner Giovanni.
Thank you, Chair. Mr. Tabata, I think we are generally in agreement and appreciative of your commitment not to dispose of any clean fill in C&D landfills on Oahu. But I think that just for clarity reasons, we're kind of loosely using the term clean fill, and I think that the order or the condition might benefit from defining what clean fill is. And so by example, I'm going to read to you a common definition of clean fill and see if you can react to that and agree to it. And it goes as follows, quote, clean fill refers to construction waste materials that can be reused or recycled in other construction projects. The term clean implies that the material is eco-friendly and free of any toxic substances that may adversely affect the health of humans and animals or contaminate the environment where they're disposed. Clean fill is generally comprised of topsoil, dirt, brick, gravel, rubble, including small rocks, sand, cement, and concrete. End of quote. Do you agree it would make sense to include a definition such as that as part of the condition referring to the disposal of clean fill?
I'm sorry, Commissioner, could you repeat the source of that definition?
The source of that definition, I did not say what it was.
Okay. That definition sounds acceptable.
Thank you. I have nothing further.
Are there further questions for Mr. Tabata, commissioners? If not, I have 4. Oh, Commissioner Axon.
Just to follow up on Commissioner Giovanni's last question about the clean fill. So would you agree that, with this definition, big boulders or whatever boulders on the site can be included in this definition, provided they are crushed to manageable sizes? And it can be, as a matter of fact, some development that I see, all those boulders are crushed and sold to other entity. Would you agree with that?
Yes, we would agree with that.
So that would address the issue about big boulders, correct?
That's correct. Thank you, Commissioner.
Thank you. Thank you, Mr. Chair.
Thank you, Commissioner Axon. Is there anything further, commissioners? If not, so I have four things I want to ask you about, Mr. Tabata, but I'll start with two prefaces. First of all, I appreciated your thanking the Commission for continuing operations during the pandemic, but I want to make it really clear the credit goes to Mr. Ordenker, Mr. Hakoda, and Mr. Derrickson for having done a truly outstanding job. We are so lucky to have the staff that we have. Secondly, I want to echo something said by Commissioners Okuda and Giovanni. I am also undecided on this project. I still have not made a final decision. But I will say that I have concerns that if I am to vote for it, I'm hoping will be addressed. And that's what my four questions have to do with. And I hope none of these come as a surprise because I believe these are all issues I have raised during our proceedings to this date. One of my concerns that I have with this project going forward, like Representative Matayoshi, is the impact on neighbors. And I'm particularly concerned that during the development process, that potential impacts, whether it be traffic, noise, runoff, or other impacts, that there's a robust communications plan so that at least the neighbors who are immediately proximate to the development will be informed ahead of time, will know exactly who to call if they see something, and the person they call has some either connection to people who can make decisions or authority to make decisions on those matters. Whether it's a noise complaint, a dust complaint, a runoff complaint, or any other concern. I thought I had made that really clear, particularly during the testimony of the noise expert. And I believe that there was the voluntary offering of a condition that there would be such a hotline or something created, but I didn't see that in your proposed conditions.
We apologize for that. There was a lot to write, and we missed that. We would definitely be agreeable to having a hotline made available.
I think a hotline is, for me, part of it. I would hope that the petitioner, along with their contractors, sort of does early and frequent outreach to the immediate neighbors, so that, not that any of these neighbors, if this was behind me, let me tell you, well, I would have been disqualified for voting, but I would have voted against it. But if I was behind it, at the very least, if it was going through, I would want to know what's going on, when things are coming up, that I'm not having to constantly guess or outreach for information, that information will be provided to me. I'm looking for, in addition to a hotline, just a robust communication with the folks who are nearby.
We're agreeable to that.
Thank you. That's my first question. My second question, and again, I hope this is not something that is a surprise. I believe firmly, as somebody who works at some points on endangered species and conservation issues, that community outreach is a really important component of the protection of a species. And even though the conditions related to the damselfly went from A through M, I believe, I did not see any condition added that talked about outreach on the damselflies population to both the neighbors as well as users of the cultural preserve. Is that a condition you are willing to include?
Yes. Yes, we would.
And I would look for suggested language that gets to the point of that folks will know in this neighborhood that there's this endangered species, there's stuff they shouldn't do. Folks who are coming in, there's stuff that they shouldn't do. There's something here that's valuable to be taken care of. The third question I had, I appreciated the inclusion of a reference to an accredited land trust being the recipient of the conservation easement, but I'd like clarification whether you're willing to accept that it would be a land trust accredited by the Land Trust Accreditation Commission.
That would
So
be,
that there's no unsureness about what is meant.
that's agreeable. Thank you.
Okay. And the final question I have to do is really related to some of the very extensive questioning that Commissioner Okuda has provided. The proposed activities in the cultural preserve, many of which will be done by volunteers, but there are some costs that will accrue to the operators of the cultural preserve. And I didn't see, while it's implied for a land trust, and Mr. Morford agreed on the record that appropriate funding would be given for funding of the enforcement of the conservation easement. I'm not sure that we have on the record to this point that there's a commitment to appropriate funding to the cultural preserve manager of their responsibilities under the management of the cultural preserve, whether that be liability insurance or whether, if necessary, I'm not saying it is, or other kinds of costs. Is there a willingness to bind the petitioner to provide appropriate funding so that the cultural preserve will be appropriately managed?
The funding or similar provisions, that's something that we would negotiate when the time comes. A blanket requirement that we provide appropriate funding. We're not sure how that how to.
If I may, Mr. Tabata. So for if you've agreed to the condition that the easement be held by the conservation easement be held by a land trust accreditation commission accredited land trust. So they have standards that make it really clear a land trust can't accept an easement without an appropriate level of funding to enforce that easement over time. So I think we've sort of baked in, not extravagance, but a sort of standard that we know that we're going to actually not just have the easement, but the easement's going to be monitored and appropriately done. I'm just looking for some level of the equivalent for the cultural preserve. And I don't have a suggestion for exactly how to do it. I'm fine with your objecting to language that says appropriate level, but I'm trying to convey the idea that I'm getting at.
That's something we're agreeable to. It's just how to word it and how to comply.
So yeah. I'm hoping to some wording would be very welcome.
But with respect to the spirit and intent of what you're talking about, yes, that's something we would be agreeable to.
Okay, so it would be great to see, in addition to the other three things I mentioned, some conditional language that would get at this idea. Those were my four things, Mr. Tabata. Thank you very much. Commissioners, is there anything further, Commissioner Okuda?
Thank you, Mr. Chair. Mr. Tabata, to follow up on the chair's question, so what type of funding will Hawaiian Memorial Park agree to fund with respect to the cultural preserve? What is Hawaiian Memorial Park willing to pay for?
I think we need to talk to the Civic Club to find out what kind of help they need from us.
So right now, Hawaiian Memorial Park really cannot give a commitment on what it intends or is willing to pay for. Is that correct?
I think there's still the challenge of coming up with language that could fulfill what the chair is thinking about. I'm not ready to give up on that yet. Right as I'm sitting here right now, I can't come up with that exact language, but I understand where the chair is coming from, and I believe we can agree to that.
Yeah, I don't think the chair's question is a surprise, because at a number of the prior hearings, I think those were the questions I was asking, and it just generated objections that is to be negotiated. But the record is what it is. Thank you, Mr. Chair. Thank you very much, Mr. Tabata. No further questions.
Thank you, Commissioner Okuda. And Commissioner Axon.
I just want to kind of confirm some of those discussions. Mr. Tabata, you agreed most of the proposed conditions by commissioners. Is there a way you can come up with language on those conditions that we can use during our deliberations?
Yes, that's what we will do. Correct.
Thank you.
Okay. Is there anything further at this time, commissioners? It is 11:45. I'm going to suggest that if there's no further questions for Mr. Tabata at this time, this would be a good time to take a lunch break and 45 minutes, returning at 12:30. If Mr. Tabata had language to offer at that time responsive to these discussions, and then we could go on to closing arguments from the city, the Office of Planning, and the interveners. Is that acceptable?
Yes.
Okay, great. It's 11:45. We will reconvene at 12:30. We are in recess. Okay, I think we're ready to go. It's 12:30. Jean, you're there with us, I assume?
Yes, I am. Thank you.
Great, thank you. Okay, we're back on the record. Mr. Yoshimori, you had an issue to bring up?
Yes, thank you very much, Mr. Chair. To be clear, the interveners are still 100% against the petition, but as a petitioner has been granted an opportunity to comment on this newly proposed condition, we'd like to ask the LUC to consider some alternative language as proposed by our expert witness engineer, should the DBA be approved. So I've sent this language to the LUC email address. I was hoping that you folks would consider it.
Okay, and you'll have a chance in your closing to address this issue as well.
Thank you.
Okay. I'll count that as the nature of a procedural question. Any other procedural questions before we proceed with Mr. Pang for the city and county? If not, Mr. Pang, you have the floor.
Thank you, Mr. Chair, commissioners. The City and County of Honolulu Department of Planning and Permitting supports the proposal to reclassify about 53 acres from the conservation to the urban district to allow expansion of a needed public service, the cemetery, the establishment of the Kawaiwai Heiau Cultural Preserve, and to create certain buffer zones. The project is consistent with the city's Kolaupoko Sustainable Communities Plan. The community plan is required by state and county charter and statutes. It is created for a vision of the community for the development of future plans. It takes into consideration the preservation of open space, preservation of historical and cultural resources, agricultural uses and resources, parks and recreation facilities, residential uses, commercial and industrial uses, and military uses. Again, we believe that the project is consistent with the city's Kolaupoko Sustainable Community Plan. The expansion of the cemetery and the proposed the expansion of the cemetery and the 14 acres for the proposed preserves are included in the Kolaupoko's community plan community growth boundary. The Department of Planning and Permitting requests that the proposed conditions laid out in the Kolaupoko Communities Plan be part of the Commission's decision, as the Kolaupoko Community Plan would not be a regulatory matter, and we would not be able to enforce those conditions without the LUCs implementing in their decisions. With respect to the other conditions that may be imposed or recommended by other parties, we ask that the Commission be specific as to those conditions, because they may, since the city may be required to regulate those conditions and enforce those conditions, we ask those that they be very specific with respect to the condition that is being talked about the water basins. Since the city is going to be reviewing the plans, again, we ask that the commission be very specific and tell us what you want our planners to review and to approve during this process. So again, to finalize everything, again, we recommend that the Land Use Commission approve this project with the condition imposed in the community's plan. Thank you very much.
Thank you, Mr. Pang. Commissioners. Commissioner Okuda.
Thank you very much, Mr. Chair, and thank you very much, Mr. Pang. Mr. Pang, are you able to comment on whether or not PVT has withdrawn its request for the expansion of the PVT landfill? I thought I read somewhere that there was a request pending before Planning Commission.
Commissioner Okuda, like you, I've heard about it, and the Planning Commission is one of the city's agencies, and the meeting that was supposed to be for the initial meeting for that request was canceled because it was withdrawn. I did not myself see the actual document requesting the withdrawal, but my understanding was the Planning Commission meeting was canceled for that reason.
However, the communion.
Okay. Next question is,
What does that got to do with you?
If
one moment.
Condition.
I'm muting the other city and county, unless you were trying to say something.
Hi, this is Deputy Director Eugene Takahashi with Acting Director Sukugawa. Just to clarify, yes, there was the testimony provided by the agent for the applicant that they'll be withdrawing the application. But as of today, the request has not come in yet.
Okay.
To withdraw the application, but they have went on record that they indicated they will be submitting a request to withdraw their application.
Thank you for that. I will note that we are in closing arguments right now, but thank you for that clarification.
Okay, thank you, Mr. Chair. Second and final question, Mr. Pang. If the Land Use Commission were to deny this petition for a boundary amendment, what are the negatives of the commission denying the petition?
Well, I note in the community's plan, it talks about open spaces, it talks about the cultural preservations of that area. So the plan did take into consideration the expansion with the open space, the preservation, the conservation easement. So all of those things would not occur. I personally can't say that they are negative. That would be up to the commission and the planners, but it would not, it would be, we believe, contrary to what the community had expressed in the community's plan.
Okay. Besides those items that you listed, can you think about any other negatives that would arise by or from the Land Use Commission denying this petition?
Well, there are talks about, I'm not an engineer, but there were talks about drainage issues, global warming, additional water coming down from the mountains. I don't know if denying this petition would, in the future, allow some remedial measures to take into those things into consideration. So negative, yeah, maybe those things might be on a negative basis if this matter is denied.
Okay, and can you point to anything else in the record which indicates negative or bad results arising if the Land Use Commission denies this petition?
At this time, I cannot point to the record that would cause any negative matter if this matter was denied.
Okay, thank you very much, Mr. Pang. Thank you, Mr. Chair.
Commissioners, are there further questions for the city and county? Commissioner Axon.
Mr. Brown, I'm just kind of wondering, because there's a lot of discussions about the petitioner's proposed conditions. And in addition, during these discussions, some of commissioners added more of those conditions. What would happen if all those conditions, after all this is done, came out that it is not in compliance, so it cannot comply with the current city and county rules or plan regulations? I'm just kind of wondering what would happen.
I think it depends. It would depend on the particular condition. We have, as you mentioned, we have rules and ordinances that provide certain guidelines and certain standards that are required for all developers. If the commission were to impose standards that are above that, you would have to be very specific. The city would not be the city would not be able to implement them unless you are very specific. If you impose conditions that somehow fall below the standards that the city has implemented in their rules and their ordinances, I think we may have a conflict and we may not be able to permit any of this project moving forward. So it depends on what type of conditions you impose on this project.
So unfortunately, we wouldn't know if the conditions that we're placing, it's going to be in compliance ahead of time or ahead of this decision. So we're not going to find out until this thing comes to the city.
Yeah.
Was there anything further, Commissioner Axon?
No, that's all. Okay. Thank you.
Commissioners, are there further questions for the city and county at this time? Commissioners, I realized that I said when I came back from break, I was going to provide some opportunity for Mr. Tabata to share language, and I jumped right into Mr. Pang's presentation. Mr. Tabata, are you prepared?
We do have some language here for the commission's consideration. Where to start? For the fill condition, what we're willing to do is add on to our condition and define that fill material is further defined as, quote, natural materials consisting of soil, clay, sand, volcanic cinder, and ash, and rock, or a mixture or combination of such materials which are not suspected to contain hazardous substances or concentrations of chemical contaminants of concern above the State Department of Health's Tier 1 environmental action levels. We got that from the Department of Health website. The intent is to mirror Commissioner Giovanni's language. And if this is different in any way, we would certainly agree to go with Commissioner Giovanni's language. That's regarding the
definition of clean fill.
The clean fill issue, correct.
I'm going to, Commissioners, I'm going to let Mr. Tabata go through his proposed language and then allow for questions.
Okay. For the cultural preserve, Petitioner shall establish the cultural preserve in conjunction with an appropriate Native Hawaiian group. Petitioner shall work with the community and the Ko'olaupoko Hawaiian Civic Club in order to establish a preservation and management plan for the cultural preserve in perpetuity. Petitioner shall pay for or otherwise assume financial responsibility for expenses associated with capital improvements within the preserve required to fulfill the conditions set forth by the Commission, all ongoing maintenance of the preserve. Petitioner shall cover reasonable expenses incurred by the group associated with the management of the preserve. Construction outreach. Petitioner shall establish an ongoing construction-related community outreach program to inform area residents and businesses milestones and activities occurring on property. In addition, the petitioner shall establish a hotline and dedicated email address to receive questions, concerns, or comments from the community and other stakeholders. Damselfly outreach. Petitioner shall establish an education and outreach program to raise awareness of the existence of the black-line damselfly and habitat area on the property. The outreach shall include informing visitors to Hawaiian Memorial Park as well as members of the adjacent community. The program shall include information on restricted activities and other best practices to avoid adverse impacts to the habitat and species. I believe those are the proposed conditions that were requested by the commissioners. We're not sure if you wanted the language regarding the conservation easement. I thought that was self-fulfilled.
It's self-explanatory as long as the phrase Land Trust Accreditation Commission accredited. Yeah.
So I believe that addresses the additional language that was requested.
Okay, commissioners. Commissioner Okuda followed by Commissioner Giovanni.
Thank you, Mr. Chair. Thank you very much, Mr. Tabata, for working on this during the break. With respect to your definition regarding fill, under your definition or proposed definition, will boulders be allowed to be disposed of at PVT?
No, it doesn't look like it. It's not defined, or it's not included in the definition. No.
So, under your understanding, no boulder will go to PVT or a similar type of construction disposal landfill. Is that correct?
Yes, that's correct.
Okay, and shifting to your section regarding the cultural preserve, I think you said that the cultural preserve provision would be directed in favor of, and I quote, an appropriate Native Hawaiian group, and I think you use a disjunctive, or the Ko'olaupoko Hawaiian Civic Club. I might be misstating what you said, so let me just ask this question. I'd be really scared, and I'm not being facetious, if the appropriate group is the Gary Okuda Civic Club. So is there any objection from you or your client if the designation is made very clear that, at least as the stated condition, the cultural preserve will be managed by the Ko'olaupoko Hawaiian Civic Club? We understand, or I understand your position that the details are to be worked out, but just so that there's no question about who the designee is entitled to be, that it's not simply an appropriate Native Hawaiian group, but the group itself is specified. Because at least for me, and I haven't made up my mind in this case again, but if I were to vote in favor of this petition, in part, it would be because the identified group is a group that has community credibility.
I believe we're in agreement. Our second sentence of that proposed condition reads, the petitioner shall work with the community and the Ko'olaupoku Hawaiian Civic Club in order to establish a preservation and management plan for the cultural preserve in perpetuity. So yes, there's a requirement that we work with the Ko'olaupoku Hawaiian Civic Club.
Okay, thank you very much. I'm sorry and I apologize to you if I didn't pay more closer attention to what you stated. Thank you, Mr. Chair. No further questions.
Commissioner Giovanni. Thank you, Mr. Okuda.
I just wanted, thank you, Chair. Thank you, Mr. Tabata. I'm in a general agreement with the language that you used to define clean fill. So thank you for that. However, I do agree with Commissioner Okuda that we just need a bit of additional clarification about large rocks and boulders. And again, appreciate your spirit to exclude those from the clean fill, but I do think we need to specify a maximum size that would be allowable. Something like, I don't know, 12 inches or less would be allowed. 12 inches or more would require crushing or something to that effect. Is that agreeable to you?
I'm trying to figure out how big we're talking about. I mean, just so that we can comply. Does anybody have a definition of boulder? 12 inches, he said. Is
Chair?
Commissioner Wong.
You know, I think I understand Commissioner Giovanni's questioning, but you know, we're getting into little too nitpicky in terms of what if it's 12 feet, 1 inch, then, I mean, we have to rely on just general indications, especially for construction, to me.
I agree. I'm happy to say boulders of approximately 12 inches or something to that effect.
I can't resist the pun to say that this conversation is getting very granular.
It is, but you know, we don't want to declassify clean fill by virtue of putting a 36-inch boulder in it, and therefore then you can put it anywhere you want.
And I hesitated to mention the pun because I didn't want to discount the significance of the concerns you're trying to raise. Excuse me, Mr. Tabata, do you have anything?
I've been asked by my engineer to reread this definition. If that's allowable, Chair.
Okay, please.
The definition is, quote, natural materials consisting of soil, clay, sand, volcanic cinder, and ash, and rock, or a mixture or combination of such materials which are not suspected to contain hazardous substances or concentrations of chemical contaminants of concern above the State Department of Health's Tier 1 environmental action levels. So the question for us is 12 inches acceptable?
12.
Uh, 12 inches is acceptable.
Okay, approximately 12 inches. Is there anything further, commissioners?
Nothing further, thank you.
Thank you, Commissioner Giovanni. Mr. Tabata, can you read the sentence regarding the hotline again? Hotline and email.
One second, I have to find it. This is regarding the construction outreach.
Correct.
Second sentence. In addition, the petitioner shall establish a hotline and dedicated email address to receive questions, concerns, or comments from the community and other stakeholders.
So I'm not trying to drill down too far, but I'm interested in it not just receiving, but receiving and responding. I mean, the kind of condition I'm looking for, the spirit of the condition I'm looking for is that, particularly with the immediate neighbors, you know, they say like, hey, you know what? I'm getting all this dust coming in right now to my house, or, you know, my wall is shaking as you guys are pounding rock. Like there's somebody who can just receive that and say like, okay, here's what's going on. Is there a way that we can address it? I'm not obligating you guys to respond to every single thing, but I think you understand the spirit that I'm trying to
convey. Right. The first sentence is the establishment of an ongoing construction-related community outreach program. So, and that program is to inform the residents and businesses of activities and milestones. So part of that program is to receive it, to provide information, but of course to receive it too. Okay. We are certain that we will be informed of concerns, and from there we will work with the community.
Okay.
Program.
Thank you. Deputy AG Chow.
I'd like to make a suggestion on the condition regarding the endangered species and the outreach. So the outreach, I think right now it's phrased as to avoid impact. It would be probably better to be phrased as avoid and minimize impact to the endangered species, because those are keywords under the endangered species law, both for Hawaii and on the federal level. So avoid and minimization.
Thank you, Ms. Chow. Commissioners, is there anything further for Mr. Tabata at this time? If not, there will be a chance to question all of the parties prior to deliberation. Thank you very much, Mr. Tabata.
Thank you.
Ms. Apuna.
Thank you, Chair. So based on OP's review and analysis of the record, OP finds that the petition conforms with applicable district standards, planning statutes, plans, and other criteria necessary for the Commission's consideration of a district boundary amendment, and provides sufficient minimization and mitigation measures to address foreseeable impacts to state concerns, including plans and efforts to minimize impacts to the endangered black-line Hawaiian damselfly. OP has proposed conditions of approval of the DBA to further address these impacts, including stormwater management and drainage improvements, air quality monitoring, gathering and access rights, and archaeological or historical protections, and protections for the black-line Hawaiian damselfly and the Hawaiian hoary bat. OP has also included proposed conditions of approval with regard to a development timetable, compliance with representations, and an infrastructure deadline of 10 years. In sum, OP recommends approval of the petition subject to OP's proposed conditions. Thank you.
I believe that was under 2 minutes, Ms. Apuna. Commissioners, starting with Commissioner Okuda.
Thank you very much, Mr. Chair. Ms. Apuna, the same question that I posed to Mr. Pang. If the commission were to deny this petition, what are the negatives do you see of such a denial?
I think I would agree with the Deputy Corporation Counsel Pang about those certain things that he mentioned, and I would also include protections of the Hawaiian damselfly, that although it sounds like petitioner would probably would put forth greater efforts than before it was discovered, they are not obligated to protect that species.
And can you list what would be the positives of denying the petition?
No, I don't think I can necessarily provide any positives of denying the petition.
So would you believe that avoiding the amount of excavation of material, which are about 400 I think 75,000 cubic yards, avoiding such excavation is not a positive?
I can't say whether that's a positive or not.
Would it be, does the Office of Planning believe that this development creates some risk of flooding or water damage to the downslope neighbors?
I think generally OP believes there could be some risk, but that with these proposed conditions, they're able to minimize or mitigate those potential issues.
Does the Office of Planning believe that the expansion of the cemetery creates some risk of injury, whether it's serious bodily injury or death from rock falls?
I don't think so, no.
Do you believe that Mr. Lim gave some testimony which could be interpreted to indicate that there is some foreseeable risk of injury or death from rockfall?
Do I believe that Mr. Lim provided that testimony?
Yes, that he provided some testimony which could be used as a basis to form a finding of fact that the expansion of the cemetery, even taking into account mitigation measures, still provides or exposes the public to some element of foreseeable risk of bodily injury or even death.
Sure, if that was his testimony, yes.
And is it true or not true, because Mr. Lim might have given some testimony on this, but he's not a lawyer, but is it true or not true that one purpose of keeping land in the conservation district is to minimize people or citizens coming into a possible foreseeable zone of danger?
Yes, I believe he said something to that.
I'm sorry?
You're asking if that was part of his testimony?
Oh no, I'm asking you whether one of the reasons of keeping property within a conservation district is to minimize the risk of citizens coming into a possible zone of danger of injury or serious bodily injury or possibly even death.
It's been a while since I looked at the conservation statutes and rules, and I don't remember there being some type of law or rule regarding having the conservation district somehow protect from those occurrences.
Can you point to anything in the statute or case authority which indicates it's inappropriate for the Land Use Commission to keep this parcel of property within the conservation district?
No, I don't think so.
Thank you, Mr. Chair. I have no further questions. Thank you very much, Ms. Apuna.
Thank you, Commissioner. Commissioners, are there further questions for the Office of Planning? Commissioner Axon.
Yeah, thank you, Mr. Chair. Just to follow up Commissioner Okura's questioning about the conservation district, do you know of any law, or is there a law that prohibits the public to enter conservation district?
I'm not sure. I'm not familiar enough with the conservation district rules and laws.
So in another word, well, if the purpose is to prevent people from, getting into like what Commissioner Okuda's implying, that the purpose of the conservation district is to prevent the people from entering the conservation district and avoid bodily injury or death or whatever. I'm just gonna try to find out if it is true or not, if there's a law prohibiting the public. Or do you know if the public, do you know if you see a public entering conservation district, whether legal or not?
I'm not aware of any law that generally prohibits people from entering the conservation district. There might be certain areas or certain things that are protected under the rules, but I'm not aware of that, what those rules or laws are.
Yeah, fair enough. Thank you, Ms. Apuna. Thank you, Mr. Chair.
Thank you, Commissioner Axon. Is there anything further, commissioners? Ms. Apuna, do you have any objections? Does the Office of Planning have any objections to any of the revised or proposed additional conditions that have been discussed today?
No, we have no objections.
Thank you. Is there anything further, commissioners? If not, Mr. Yoshimori, it's your time. Mr. Yoshimori? Is he frozen? Ah. Yeah. Let's see, Mr. Yoshimori. Okay, I think he's logged out and might be trying to log back in. So let's just wait a moment.
Chair?
Commissioner Wong.
As we're waiting, did you ask the city if they objected to any of the changes that the petitioner request stated?
I did not ask the city. I sort of felt that Commissioner Axon's question regarding the city's enforcement of conditions that differed from city ordinance got at that, but I'm more than happy to have Mr. Pang answer that question. Does the city object to any of the conditions that have been discussed today by the commission? You are not muted, but I cannot hear you, Mr. Pang. Can anybody else hear Mr. Pang?
Can you hear me now?
Now we can, yes.
Okay, sorry. The city generally does not object to the conditions that you discuss. Like I said, you have to be the drainage conditions. They have to be specific so our engineers know what to implement when they're reviewing the plans.
Yes.
So that's the only caution that we have.
Okay.
And there are some reporting and monitoring requirements that may not be so clear as to who they report to, and what monitoring the information, who they submitted to, whether it's Office of Planning, whether it's the LUC, or whether it's DPP. So we're just cautioning you to just a little bit be more specific on some of the conditions that you impose. But we don't object in general to the conditions.
And Mr. Pang, we can expect that if the commission acts favorably and adopts said conditions, specific wording would be, or some specific guidance might be provided by the city?
Yes, yes.
Thank you.
Yes, if so, yes, if asked, we could do that.
Okay. Ms. Chow.
Because I note that Mr. Yoshimura and the interveners are not currently present in the meeting, you may have to ask Mr. Pang to repeat that when they come back on.
Yeah.
Thank you.
Actually, I was intending, when Mr. Yoshimori is able to rejoin us, to ask at what point they were unable to hear what was going on.
Mr. Chair, I'm still on, and I noticed that there are some of the other commissioners looks like they're frozen on my computer too.
Oh. If you're frozen, raise your hand. Yeah, no, I think it's just your computer. I can see you have 7 live bodies.
Okay.
You know what? Oh, Mr. Yoshimori, you're connecting to audio. Okay, you're now on mute.
Sorry about
Aloha. Welcome back.
Scariest thing ever.
That's very frustrating. I'm very sorry. At what point were you unable to hear what happened?
I think it was Ms. Apuna's questioning. So I think she had just answered about any objections to the revised conditions. And then I got cut off.
Okay. Ms. Apuna answered in the negative. There are no objections by the Office of Planning to the proposed conditions. There was a further question. Was there a further question for you, Ms. Apuna, at that point? Okay.
No, I don't think so.
And then we were turning to you, Mr. Yoshimori, but then in the meantime, Commissioner Wong asked me to re-ask my question to Mr. Pang, whether the city and county had any objections. I'll let Mr. Pang restate his response.
Thank you, Mr. Chair. As I stated earlier, in general, the city doesn't object to the proposed conditions imposed by the Office of Planning. But again, we caution the commission with respect to things that the engineers and the planners must review for the grading permit and other permits that will come before the commission. So we ask a little bit more specificity if possible, and a little bit more guidelines for the planners and engineers. Thank you.
And I suggested in a follow-up question that, or rather implied rather than made it explicit, that when we eventually adopt the form of the order, if this petition is successful and said conditions are made, that in the course of the preparation of the form of the order, such non-substantive but clarifying provisions could be added.
The city was agreeable to that.
So I think that's it, Mr. Yoshimori. Are you good?
Yeah, thank you. And thank you everyone for catching me up to speed.
No,
Thank you.
It is, having been subject to that while trying to chair this meeting, it is just so frustrating. You have my sympathies. And you have the floor. It is time for your closing argument.
Thank you. Before I begin, I wanted to thank the commission, the LUC staff, Office of Planning, DPP, and the petitioner for allowing us to participate in these hearings. We all know that you're here because of us, so thank you. We'd like to summarize our many concerns with the petition. Point 1, there is large community opposition. The LUC has received many written and oral testimonies against the development, and our online petition to the LUC has over 2,900 signatures in opposition of the proposed district boundary amendment. Point number 2, the petitioner has not shown a need for expansion. At the statewide level, the petitioner's statewide marketing study had a severe error, overstating the number of projected burials by 27,000 in scenario 2 and over 41,000 in scenario 1. In addition, the study only assumed 1 person per burial spot, which does not take into account the current burial practices of allowing more than 1 person per burial plot. With these adjustments, we've shown that there is a projected surplus of cemetery plots on Oahu through 2040 without the petitioner's expansion. At the park level, Hawaiian Memorial currently has 37% of their graves unused, 37%. Yet the petitioner is asking to expand on conservation land so that they can continue their current unsustainable business practices. If HMP adjusted their business model and allowed additional people per burial plot, petitioner could continue providing burial services to Oahu, continue generating revenue, and sustaining jobs far into the future. Given the lack of the need for extra burial plots and given that the petitioner has been unwilling to provide how much revenue from the expansion would remain in Hawaii, the proposed development is contrary to the State of Hawaii Constitution, Article 11, Section 1. Point number 3, The land is a critical habitat for the endangered black-line Hawaiian damselfly. Although the Office of Planning has proposed mitigation plans to protect the black-line damselfly, the U.S. Fish and Wildlife Service has not reviewed these plans and in fact has strong opposition to the project. The Fish and Wildlife Services stated their concerns that the project could be detrimental to the prolonged long-term survival of the population. The petitioner's damselfly expert testified that the damselfly, quote, probably will use something on the order of a couple of acres, unquote. But the petitioner plans to grade most of the existing area and leave only a 164-foot buffer around that habitat. Thus, the proposal is contrary to the district standard HAR 15-15-20, Section 5. And the project does not conform to the Hawaii State Plan, HRS 226, Policy 11-B-6, and does not conform to Priority Guideline 104-B-10. And if the DBA is not granted, the endangered habitat will be protected from potential habitat destruction from the project. And in addition, the petitioner testified that if the DBA is not granted, they are willing to coordinate with the DLNR and the U.S. Fish and Wildlife Service on appropriate cost-effective measures to ensure the protection of the damselfly. So again, if the DBA is not approved, the petitioner is willing to help protect the damselfly. Point number 4, there will be destruction of 9 existing historic sites on the property. Thus, the land retains the characteristic of the Conservation District as HAR 15-15-20, Section 4. And also, the project does not conform to the Hawaii State Plan, HRS 226, Policy 12-B-1 and 12-B-4. Point number 5, Native groups already have the right to access to historic and cultural sites, and the urban designation is not required to maintain the sites. The petitioner is obligated to allow access to the area to the Ko'olapoko Civic Club under the Hawaii State Supreme Court case, Public Access Shoreline Hawaii versus the Hawaii County Planning Commission. HAR 13-5-22 currently allows activities to maintain historic sites in the Conservation District, including removal of invasive species, minor repair, maintenance to existing structures, and planting native and endemic plants. They're all currently allowed. In addition, the petitioner stated that should the boundary amendment be denied, they would allow the Civic Club to be at the heiau to do whatever they wanted to do and would permit access through the cemetery to community members who wanted access to the heiau. So if the petition is denied, Hawaiian Memorial would still let cultural practitioners utilize the area. Point number 6, the petitioner is requesting a violation of the State Supreme Court case, Kapa'akai Oka'aina versus the Land Use Commission. In that case, the court said that the LUC must make specific findings and conclusions to 1, the identity and scope of cultural historic resources, 2, the extent to which these resources, including traditional and customary Native Hawaiian rights, will be affected and impaired, and 3, any feasible action the Commission may take to protect such Native Hawaiian rights. The petitioner has done an outstanding job in number 1 in identifying additional historic sites. However, for number 2, they have not defined the effect or impairment of these proposed actions. There are many unanswered questions on how the cultural and historic resources will be used. A few of them are, 1, determining who is a practitioner and who will have access to the cultural preserve has not yet been determined. While we just recently had a new condition identifying who the manager of the cultural preserve is, the funding and liability has not yet been determined. The holder of the conservation easement has not yet been determined. Who will be buried in the heiau complex and the process for application has not been determined. Those are just a few of the questions that are not yet brought forward. The petitioner stated that a preservation and management plan will be developed later. As in Kapa'akai, Hawaiian Memorial is requesting that the LUC adopt a future, unseen management and preservation plan, which would not allow the Commission to independently assess the impacts of the proposed reclassification on customary and traditional practices as ruled in Kapa'akai. Point number 7, there is acknowledged rockfall hazard and potential harm to people. In GeoLabs' rockfall simulation for the cultural preserve, approximately 86% of their simulated rockfalls could pass to the preserve's upslope area. The only proposed mitigation for this area was a rock fall hazard warning sign. The petitioner's expert witness was not willing to guarantee that people aren't going to get hurt. Some of the property is currently in the Conservation District limited subzone, which was meant to encompass lands necessary for the protection of health, safety, and the welfare of the public by reason of the land's susceptibility to landslides, and also if they have slopes greater than 40%. Thus, the land retains the properties of the Conservation District as stated in HAR 15-15-20, Section 2, and specifically for the limited subzone. Point 8, there are still flooding concerns with the proposed development to the nearby residents. And we thank the Commission for getting the petitioner to agree to increasing the detention basins to 63,500 cubic feet. But at the same time, our understanding is that according to the Hawaii administrative rules, the evidentiary portion of this hearing has been closed, and we would consider this new evidence. This condition will impact the design of the proposed cemetery, and the impact has not gone through the complete DBA review process. For example, there's been no design put forward to the Commission to assess the larger retention pond's impact to cultural and historic resources, nor has the other agencies been able to comment on these, such concerns as raised by Mr. Pang. We ask that the Commission consider the lack of public review on this change and consider denial on this and our other points. In the event the Commission does approve the DBA, we've submitted some alternative language for consideration for the newly proposed condition on the retention basins. Point number 9, the project has adverse impacts to the existing views. This site will undergo extensive grading activities, cutting and filling in a mountain. The project includes grading of 33.6 acres, and the majority of the western hillside will be excavated to achieve height reductions between 40 and 100 feet. Many of us have seen the current forested area in our visit to the area, and these changes will be extreme and will have extreme adverse scenic impacts. Thus, the land retains the property of the Conservation District as HAR 15-15-20, Section 4, for the preservation of scenic sites. And it does not conform to the Hawaii State Plan, HRS 226, Priority Guideline 104B13. Point 10, the area is part of the Kava Stream watershed. The petition area is part of the watershed, and in addition, portions of the Lipalu Channel are likely federal jurisdictional waters as a tributary to the Kava Stream, which discharges into Kaneohe Bay. And again, the land retains the properties of the Conservation District as HAR 15-15-20 to protect watersheds. And it also does not conform to the Hawaii State Plan, HRS 226, Priority Guideline 104B-10. Point number 11, the project is contrary to the Ko'olaupoku Sustainable Community Plan. The DPP and the petitioner says the KSCP is only sets forth regional land use policies and guidelines. However, the KSCP language is not general. It specifically identifies Hawaiian Memorial and Pohainani, saying there must be a 2,000-foot buffer between the two. Councilmember Kimberly Pine further clarified by submitting a letter to the LUC saying it was the council's intent to set the buffer at 2,000 feet from the Pohainani property line. As the DPP's Dina Wong pointed out, the current expansion is only 1,350 feet away from the property line, not 2,000. So the LUC's decision criteria states that the Commission shall specifically consider the community and development plans. And this project clearly violates the explicit language regarding Hawaiian Memorial in the KSCP. Point number 12, the land is needed to protect the environment. We are seeing the devastating effects of global warming. Just this year, we see the unprecedented fires on the West Coast. And we have so many Atlantic hurricanes, they ran out of names. Our meteorological expert testified there is evidence of global warming, and we need trees to limit deforestation. The DPP has also said concerns regarding the loss of forest as a result of the cemetery expansion, which is contrary to the city's efforts to encourage the planting and preservation of trees. So this project is contrary to the Hawaii State Plan, HRS 226 11-B-1, to exercise an overall conservation ethic. So for these reasons, as it was 10 years ago in the prior Land Use Commission decision on Hawaiian Memorial, It's clear that the proposed district boundary amendment is contrary to many of the decision-making criteria for the change of conservation district designation. And based on these factors, we humbly beg the Land Use Commission to deny the request. Thank you.
Thank you, Mr. Yoshimori. Can I clarify before I provide for questions? You said that you've provided some alternate language.
Yes. I sent that to the Land Use Commission's email address, and I also CC'd Mr. Hakoda.
Can you share those right now as well?
Oh, sure.
Mr. Chair, this is Riley.
Yes.
I can forward the email to the commissioners if that would help.
Please do that as well, but I will still ask Mr. Yoshimori to review.
Okay.
And to the parties, Mr. Hakoda.
So the language that we have proposed is, the petitioner shall prepare a detailed detention basin analysis using appropriate computer modeling software to determine the size of the detention basins to be constructed immediately upstream of each of the existing drainage inlets that will receive runoff from the project. The inflow will be calculated based on at least a 10-year, 24-hour rainfall event, and the basins shall be designed so that the outflow from each basin will be limited to the capacity of the existing downstream drainage improvements. The detention basin analysis shall be submitted to the DPP and the interveners for approval. After the detention basin analysis is approved, the detention basins shall be constructed as soon as practical after the start of grading for the project.
Yes.
This is
Hakoda.
I'm having difficulty transmitting Mr. Yoshimori's email. Is it possible that he might be able to transmit it from his end?
I'm not sure that he has all the contact information for the commissioners.
What's caught? Yeah, I think if he resends it, perhaps either Mr. Orodenko or myself might be able to forward it to the commissioners.
And the parties.
Yeah.
Okay. We're coming
I'll
up
send
on
it to Mr. Derrickson and Mr. Orodenker. Is that okay?
Please. Okay. We're coming up on a full hour of being together, 55 minutes. Does anybody want to start with questioning of Mr. Yoshimori? Commissioner Axon.
Just a clarification, Mr. Is your proposed language, is it in addition or in replacement of the petitioner's proposed condition?
It's to replace the petitioner's proposed condition.
Thank you.
Although for clarification, we do, we're citing that we're hoping the Land Use Commission will deny the district boundary amendment.
That is clear from your presentation.
Thank you.
Commissioners, Commissioner Chang.
Thank you, Mr. Chair. Actually, mine is more going to be a comment than a question. Am I on? Oh, Mr.
You are on.
Yoshimori, I really want to thank you for your diligence and obviously your patience and persistence. I've appreciated the value that you've brought to the hearing. So I do want to thank you for your participation. Thank you.
Thank you. Thank you, Commissioner.
Commissioners, questions at this time for Mr. Yoshimori? Otherwise, I'm going to recommend that since we're trying to get some information out to him and all the parties, as well as get ready for a break, that we would take a break now. Commissioner Giovanni?
Thank you, Chair, and thank you, Grant. I've known you for a long time. You've done a great job and a very professional one representing your interests, and I greatly appreciate how you've how you've performed and conducted yourself on behalf of your constituents. It couldn't be more impressive. So thank you for that. I was trying to follow your reading of your proposed language for a condition about the drainage retention ponds in the event that we do approve the petition. And I didn't quite catch it whether or not you were identifying a specific methodology for the analysis, even though your expert testimony put forth on your behalf did identify the city and county plate six methodology. Could you address that confusion in my mind?
I did get this language from our engineer, who I don't have access to at this moment. I believe he was referring to plate 6 in order to calculate that 10-year, 24-hour rainfall event, but I'm not 100% certain, and I will clarify offline and get you the information.
Also, could you clarify, because I do think there might be a conflict between your expert witness testimony that was recommending a 100-year, 24-hour storm as the basis for the plate 6 analysis, as opposed to a 10-year, 24-hour storm. So if you could clarify those 2 points, that would be appreciated.
Will do. Thank you.
Thank you.
Okay. It's 1:29. Let's take a recess till 1:40. And then we will go into questioning of intervener Yoshimori. Recess till 1:40. Welcome, Commissioner Cabral. Let's go back on the record. It's 1:41, and Commissioner Okuda, you have the floor to question the intervener.
Thank you, Mr. Chair. Mr. Yoshimori, let me echo what Commissioner Chang had mentioned about your participation. And I thought I was a person who pays attention to the case law, but you raised a point which frankly I overlooked. And what I would like to do, I'm not going to ask you a question on this because you raised the point, but I'm going to ask if the chair allows that later on when we go back, and if we have a possibility of asking the other parties to comment, I would ask the chair to ask the other parties to comment on your statement about non-compliance with the Kapa'akai case. And specifically, this is the section with the chair's indulgence. If I can just read part of a paragraph, or actually read this paragraph. This is found at 7 Pacific 3rd at page 1087. I'm sorry, I don't have the Hawaii reports section, but later on, with the chair's permission, I would like the other parties to comment on whether or not we have a Kapa'akai problem here, or whether we don't have a problem. And I'm actually more interested in, if any of the parties say we do not have a problem, why we do not have a problem. And so if I may quote what the Hawaii Supreme Court said about improper delegation of Kapa'akai duties, and I quote, KD argues, however, that Hawaiian rights are adequately protected because the LUC's condition number 18 requires KD to, quote, preserve and protect any gathering and access rights of Native Hawaiians who have customarily and traditionally exercised subsistence, cultural and religious practices on the subject property, close quote. KD further maintains that its conceptual RMP will adequately protect any such rights. This wholesale delegation of responsibility for the preservation and protection of Native Hawaiian rights to KD, a private entity, however, was improper and, one moment please. And misses the point. These issues must be addressed before, and the word before is italicized for emphasis by the Hawaii Supreme Court. These issues must be addressed before the land is reclassified. So later on, with the chair's permission, I would ask the chair or allow the other parties to comment on whether or not we have a kapa'akai issue, and if there is no kapa'akai issue, why is there no issue, especially since the specifics of the terms and condition of the cultural preserve management have not been specified. Thank you very much, Mr. Chair, and I've again learned that, as I've learned from listening to Commissioner Giovanni, we should pay attention to what engineers have to say.
So the parties, consider yourself fairly warned. You will receive this questioning from Commissioner Okuda after the general questioning of Mr. Yoshimori. Because my intent is to allow the commissioners to ask any final questions before we move into formal deliberations, excuse me. Commissioners, are there other questions for Mr. Yoshimori? Commissioner Giovanni.
I was just wondering if Mr. Yoshimori had enough time to get answers to the two questions I asked previously.
I have. Is it okay for me to answer?
Please,
Chair?
proceed.
Okay.
Yeah.
So I did speak to Mr. Hyam, and he said that the recommendation that he's put forward, he felt was the most fair and achievable method for a developer to follow. So he based it on the rational method, and he based it on that 10-year, 24-hour flood calculation. But he did say what was more important is it's the matching of the outflow of the basins to match the current capacity of the city and county's receiving areas. So that's a key element that he wanted to push forward, is that we have to match, so retain the water so that it only flows off at the level that the city and county can handle.
Yeah, generally speaking, a given rain event will produce a certain volume of water. And if you allow that volume of water, if it's a great amount, to run off all at once, it will overwhelm the existing infrastructure and flood. So the idea is, if you build a retention basin large enough, you will survive the storm, and then the water can be released at a rate that is compatible with the downstream infrastructure and avoid flooding. That's the general idea behind all these methods. And the key is the size of the storm and then the method that is used. So in Mr. Hingham's testimony, he strongly suggested that the rational method was not adequate. Are you now saying that he is saying that it is adequate, provided you use the right size storm?
I think he's saying that in conjunction with the rational method, by matching the outflow with the city and county's ability to receive it, that it will be, it will match, it will address the concerns. He did say that this should result in a retention volume that's greater than or equal to the, I forget what the exact number was, 62,000 cubic feet.
5 times the original estimate.
Yes.
So it'd be 5 times or more greater than the original estimate, rather than a priori just agreeing to a bigger 5 times 62,500. Thank you for that clarification, and I yield back, Mr. Chair.
Thank you, Commissioner Giovanni. Commissioners, are there further questions for Mr. Yoshimori? Anything, commissioners? Okay, if not, then commissioners, you may ask any final questions you have of any of the parties before we go into formal deliberations. And let's start with Commissioner Okuda's questions regarding Kapa'akai Oka'ina. Oh, you're muted, Commissioner Okuda.
Thank you, Mr. Chair. Perhaps each of the parties, starting with the petitioner, can answer the question whether or not, because the terms and conditions of the cultural preserve have still not been determined whether or not we have a violation of the Hawaii Supreme Court's not only admonition, but rule as stated in the Kapa'akai case.
Mr. Tabata.
Yes, thank you. The Kapa'akai case set forth a 3-point test. Okay, we are in compliance. The 3-point test is, first we have to identify the cultural resources. 2, we have to see if there are any impacts to the cultural resources as a result of our project. And if there are impacts, then what reasonable mitigation can be done to address those impacts. Okay, so we had our expert, Dr. Tricia Kehaulani Watson, do a cultural impact assessment according to Kapa'akai. Okay, and what her determination was first of all, there are cultural resources, and she identified them. Okay, one of them being the heiau. And number 2, the second point of the test, what impacts? Her conclusion was that there will be no impacts because we will not touch, affect, do anything to the cultural resources. That was her conclusion. So in answer to number 2 part of the test, the answer is no, there will be no impacts. Okay, so in other words, you don't get to number 3 where you have to talk about mitigation to address those impacts. Okay, so what that means is when it comes to the preservation plan and the management of the cultural resources and the cultural preserve, what that is stewardship, which goes above and beyond what Kapa'akai requires. So just to reiterate, we don't get past number 2 in the test. There are no impacts as a result of the project. That's what the cultural preserve is for, to preserve the cultural resources. So that's why we're in compliance with Kapa'akai. And that's why this commission accepted our EIS when we did a Kapa'akai test way back when, over a year ago. And that's why we're in compliance.
Well, Mr. Tabata, if I may ask, does the acceptance of the environmental impact statement mean that the Land Use Commission is prohibited from engaging in the analysis required by the Kapa'akai case?
No, and I'm glad you asked that question because it was raised that by the interveners that there is no requirement that we comply with Kapa'akai when we did our EIS, and that I disagree with. Okay, the Kapa'akai test needs to be done back then when we're trying to evaluate what impacts are going to happen because of our project. And at that point in time, we were required to do a cultural impact assessment to determine whether or not our project would impact cultural resources. Okay, so the only way I know how we're going to protect cultural resources is if we identify them, if we figure out are there going to be any impacts to those resources, okay, and if there are any impacts, what mitigation can we do to protect those resources, okay? So that's why I think Kapa'akai applies at the EIS stage. Okay, there's no case law on point, I'll admit that, but as representing petitioners, I would require that. If you're going to do EIS before the commission, you do a Kapa'akai analysis.
So your position is there is no evidence of any cultural impacts. Am I understanding you correctly? So you don't get to the 3rd prong of Kapa'akai?
Correct. That was the conclusion of Dr. Watson.
Are there any, or is there any evidence, no matter how slight that evidence may be, that in fact this proposed expansion in fact does have at least some cultural impacts?
No, we're going to protect the heiau. We're going to preserve it. the sites, the archaeological sites that are for data recovery, we've passed that through. We've gotten the approval of SHPD. Okay, so that's all in conformance with the law. The harvesting of the ferns, we're making sure that there's an ample amount of ferns still growing in the cultural preserve and other undeveloped areas so that cultural practitioners can continue to harvest and care for those plants. So that's the basis for Dr. Watson's conclusion. There will be no impacts as a result of the project to cultural resources. And yes, that's why we do not get to number 3. And that's why the non-existence of a preservation plan is not a violation of Kapa'akai. That's stewardship above and beyond what Kapa'akai talks about in its three-part test.
Do you believe that reasonable minds could differ based on the record about whether or not this project creates at least some cultural impacts?
Based on the record we have, no. We have only one cultural expert in this case. Only one. No other experts with the credentials of Dr. Watson testified in this case. All the parties were given an opportunity to produce such a witness, but none did. So as far as our record goes, we only have that one expert's testimony. So no, I do not believe we can have differing opinions.
Commissioner Okuda, did you, I want to not lose sight of, you wanted to make sure to ask all 3.
Yes, and I have one last question to Tapata. Is the Land Use Commission prohibited from looking at all evidence that has been adduced in this record, in addition to whatever Dr. Watson may have testified about, to determine whether or not there have been or will be cultural impacts?
The ultimate conclusions in the cultural impact assessment required expertise to come to that opinion testimony. The record is devoid of any other expert testimony, in my opinion. I don't see where that information can come from.
Thank you, Mr. Chair. Thank you very much, Mr. Tabata.
Do you want to pose the same question, Commissioner Okuda, to the city and to the Office of Planning?
Yes, yes, please. Mr. Pang, if you can answer the same question I asked Mr. Tabata. Do we have a illegal delegation issue as set forth in the Kapa'akai case?
First of all, I'm going to defer to Mr. Tabata with respect to his expert, but I just want to identify certain things that were presented while I was monitoring this commission hearing. Mr. Tabata presented his cultural expert, Ms. Watson, and in addition, the intervener presented numerous neighbors and people who visited the area and identified particular cultural practices and cultural resources. And Mr. Tabata and his clients indicated that whether the permit is approved by the Land Use Commission or not, there will be no interference and there will be no detriment to whatever is currently being done and what is going to be done in the future. So I think with respect to that, I don't think you're delegating anything. The fact that there is no specific agreement as to what type of insurance policies are going to be adopted, what would be the amount of compensation. I don't think that that's what the Kapa'akai court was looking for. You already have on the record the cultural practices. I recall Commissioner Chang asking all of the neighbors if they do cultural practices in that area, and those who said yes, there is no interference by the petitioners. So with respect to Kapa'akai, not knowing that much about that case, I would say I don't think that. I think that the commission has delved deeply into cultural practices. in this particular petition.
Okay.
Thank you.
Thank you very much, Mr. Pang. With the permission of the chair, I'd like to pose the same question to Ms. Apuna.
Please.
Ms. Apuna, can you please tell me whether or not you believe there's a Kapakai issue?
I think so. OP would also defer to Mr. Tabata's cultural witness or expert on this. So we wouldn't think based on that there is a Kapakai issue.
Can I ask you that even though life has no guarantees, do you believe that if we proceed on this record, there still is some risk of reversal on appeal before the Hawaii Supreme Court?
I think there's always a risk. The level of risk I don't think is particularly high.
Okay, thank you very much. Thank you, Mr. Chair. No further questions.
Commissioner Chang. Sorry, it's recess at home, so there's some background noise from the homeschooling.
Thank you very much, Chair. Mr. Tabata, I'm just going to do some follow-up questions from Commissioner Okuda. Well, are you saying that the determination of Kapa'akai is a matter of an expert opinion, and it's not based upon facts provided by cultural practitioners or people who are exercising those rights?
It is based on facts, and that's what Dr. Watson used to come to her conclusion. She didn't just say there's no impacts. She explained it much more eloquently than I can. Yeah. She went through and identified the cultural practices that are ongoing, that exist there, and she explained why there's no impacts to those resources. That's the primary driving force behind, or not the driving force, I should say. It's the result of the cultural preserve, is that we're gonna save these resources. Well, the Civic Club will, by managing the preserve and all of the cultural resources there.
And I guess, Mr. Tabata, why I believe that Kapa'akai has been satisfied, but I disagree with your legal analysis. I ultimately believe that a determination of Kapa'akai and compliance is really an obligation of the Land Use Commission. We have the affirmative obligation to preserve and protect the cultural and natural resources. It is the responsibility of the applicant to provide us relevant information to, one, identify what those resources are. And I think Mr. Pang was right. I went through detailed questioning. There were numerous, in my view, testimony both by people, the public, during the community, the public portion of the testimony, that there were those who collected ferns, those who accessed, those who went up to the area to do, they were working with the hail, that the resources is, in my view, is much more than just the hail. So in my mind, there was a sufficient identification of what those resources are. So I think the first test of the Kapa'akai was satisfied, at least to my my satisfaction. The second test, you're right. Is there any impacts to this project? I believe that there are some, that there will be a replacement of some of that area where the ferns were growing. There may be an access where cultural practitioners have traditionally accessed through the residential area. So I think that there are some of those sites maybe that were identified during the AIS will be set for data recovery. They're not going to be preserved. So I think that there are some impacts. However, with respect to the third prong of the test, are there measures? And I agree with you. In my view, the cultural preserve, that is a reasonable measure all of the conservation easement. It is the restoration of the site. I think that there are benefits. So I have been satisfied based upon the information that was presented, that as a land use commissioner, I have felt comfortable that the information that's provided, that we are, at least I am able to go through that kapa'akai analysis for me to make that determination as a land use commission, because ultimately that is our obligation, our constitutional obligation. So while I may, while I have a contrary opinion to Mr. Yoshimura, I don't think that kapa'akai has not been complied with. I disagree a little bit with some of your arguments, but we get to the same point. So, but that's why I take great pains in asking those kinds of questions from these witnesses, because I do believe it's a factual determination, and then ultimately we make that decision. So that was my only point, Mr. Chair. And I'm, Mr. Tabata, you don't have to agree or disagree with me, but that's my point. Thank you.
Thank you very much, Commissioner Chang. Yeah, I have some responses on this, but they are more in the matter of deliberation than they are of questioning of the counsel for the parties. Commissioner Wong.
Thank you, Chair. First off, well, the main thing is we received the language from Mr. Yoshimori, from Mr. Derrickson. I just wanted to get a gist of what Mr. Tabata thinks about the language.
Mr. Tabata.
Thank you. Okay, we did get to review the intervener's detention basin language, and it's acceptable. We would like to take out the part about intervener's approval. We don't see that as a part of the normal process. So the words "and the interveners" in the second to the last sentence, we would ask that be deleted. So that sentence would read, "The detention basin analysis shall be submitted to DPP for approval," period.
Okay. Is that it, Mr. Tabata?
Yes, otherwise their language is acceptable, agreeable.
Thank you. Chair, can I ask the state and the OP and the city if they're okay with the language?
Yeah, and I'd like to also hear from Commissioner Giovanni, who raised these points on this language.
Commissioner Giovanni, do you mind if I ask the OP in the city before I yield it to you?
That would be fine, Commissioner Wong.
Thank you. City, Mr. Pang, what do you think about the language with the changes that Mr. Tabata stated?
That's the one that was sent by Mr. Dickinson earlier. We didn't have a issue with that. We are presenting it to our engineers, but at this time we don't have a problem with it.
Okay, thank you. OP?
Yeah, we'll defer to petitioner and their modified language for that petition.
Okay. Thank you, Chair. Thank you to all those members that spoke about this. I'm deferring to
Commissioner Giovanni. And just in case this helps with our discussion as we finish up this phase, generally the practice of this commission is we make it really clear on our motion, if a motion is taken to approve, to express the intent, and then we leave it to our expert staff to draft language consistent with the intent of our motion. And then we don't until later actually approve the form of the motion, where if for some reason the staff has not gotten it, we then clarify that at that final hearing that we've taken an action consistent with the intent of the motion. Commissioner Giovanni.
Thank you, Chair, for that added clarification, because I was hoping you would say something like that. I also heard that this is consistent with the language that I was looking for. I had also indicated a preference to strike the phrase "and the approval of the intervener." I don't think that's part of the regular process. And let me just ask for clarification, do we need to define the acronym DPP? I mean, I know what it is, but is that well known in the vernacular of this case?
It will be defined in the course of the decision in order, findings of facts and conclusions of law.
That'd be great. So yeah, I'm okay with it.
Okay. Commissioners, questions for any of the parties? Mr. Yoshimori, from me, without questioning for 1 second that I am very clear on the position of the interveners, but you heard the language that I asked for regarding construction management coordination with the community. Did you have any clarification or reaction or objection to that language?
No, I do not. Thank you.
Okay. Commissioners, is there anything further? Questions for the parties? If not, then the commission will now conduct formal deliberations concerning whether or not to grant or deny the petition. I will note for the parties and for the public that during the commission's deliberations, I will not entertain any additional input from the parties or the public unless those individuals or entities are specifically requested to do so by me. If called upon, I would ask that any comments will be limited to the question at hand. The commission held hearings on the merits of this petition on November 21st, 2019, January 22nd, May 6th, June 8th and 9th, and 24th, and August 12th of 2020, and held closing arguments which were concluded today. Commissioners, let me confirm that each of you have reviewed the record and read the transcripts for any meeting you may have missed and are prepared to deliberate on the subject docket. After I call your name, would you please signify with either an aye or a nay that you are prepared to deliberate on this matter? Commissioner Axon.
Yes, I am.
Commissioner Cabral.
Yes, I am.
Commissioner Chang. Commissioner Chang.
Yep. Aye.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes.
Commissioner Wong.
Aye.
And I, as chair, am also prepared to deliberate on this matter. Commissioners, I will entertain a motion that the LUC accepts or does not accept the Hawaii Memorial Life Plans petition for the district boundary amendment. The motion should state the reasons for acceptance or non-acceptance of the petition, as well as the conditions that will apply, and you can refer to, for instance, the conditions proposed in today's discussion and accepted, or the conditions proposed by OP or other such entities. I'll entertain a motion. Commissioner Okuda, are you raising your hand?
Yes, Mr. Chair. With the chair's permission and concurrence of the other commissioners, if it's at all possible, is it possible to we first talk about what might be the reasons why we should grant this petition, so without committing ourselves to granting it, and then discuss the reasons why we should deny the petition.
This is Dwayne. Can I help you?
Hold on 1 second. Mr. Pang, I'm going to mute you. Sorry.
Okay, and without committing ourselves, because at this point I'm still not sure, we could then discuss the reasons why it would support a decision to deny the petition, and do that first before making a formal motion, but I'll leave it up to the chair.
Having just read all the dates in which we've reviewed the record on this matter, I do understand the conflicted nature, but my preference would be for the discussion to happen in the context of a motion.
Thank you, Mr. Chair. I withdraw my request.
Commissioners, is there a motion to accept or a motion to deny? or if perhaps, as Commissioner Okuda is suggesting, we just need to discuss it more before a motion is ripe. If nobody is jumping forward to make a motion, Commissioner Okuda, do you wish to suggest the reasons why a motion in favor would be warranted, as you suggested?
Yes, and I apologize, Chair, if I don't have the laundry list here. But one of the reasons to grant the petition is the fact that there's a proposal to do something which I don't believe we see very much, which is a funded cultural preserve with an entity that has respect in the community. It basically gives something which a landowner is not required to do. A landowner is not required to preserve cultural resources. A landowner, I believe, is entitled under the law to engage in benign neglect, and as long as there's no affirmative action destroying things or degrading resources or cultural monuments, frankly, there's no real sanction. So one thing in favor of this petition is it gives a benefit which normally you cannot get. The other benefit I see is, even though there might be conflicting evidence here, that there could be mandated drainage improvements which possibly should have been done when the subdivision was earlier built, but haven't been done. So the development may require the construction of things to protect the downslope residents. And so I see the main factor in favor of granting the petition is the cultural preserve and the representation that the holder of or the manager of the cultural preserve is going to be the Ko'olapoko Hawaiian Civic Club, a well-recognized entity, and there's a representation that funding will be provided.
Thank you, Commissioner Okuda. Commissioner Cabral, you have raised your hand.
Yes, thank you. Another favorable outcome of the petition, approval of the petition, would be the damselfly. While there's, again, conflicting information as to whether that's going to be adequate or not adequate, I would say that the reason it's becoming extinct is the fact that no one has done very much in the past to protect it. So therefore, the efforts of the petitioner in establishing some type of protected area, I think is going to do it better than just completely ignoring it. And as they said, by if you do nothing, there's no law against doing nothing of preserving something that's on your property. So I think that the petitioner will make those efforts and therefore preserve that the damselfly as an endangered species. So that's one more to the positive list. Thank you.
Thank you, Commissioner Cabral. You know, I'll just use this opportunity to state my by and large agreement with Commissioner Chang's analysis of the Kapa'akai issue. You know, mostly I agree or disagree with folks. I rarely take umbrage to arguments before us. I do take umbrage to the suggestion that we were violating Kapa'akai. And I do take umbrage to Mr. Tabata's suggestion that you need to be an expert in order to meet the standards needed for a Kapa'akai analysis. I think cultural practitioners, by presenting fact, are a legitimate separate part of that standard. When I think about Kapa'akai, I can never stop but think about Malia Akutagawa's great summary of it, which is, you know, there's the Supreme Court's formal language, but Malia says, the question is simple. What you get, what going to happen, what you going to do? And the parties did a good job in describing what was there, what you get, They did a good job in describing the very minimal impacts on what was going to happen and the very specific and planned out tasks for any impacts that will occur, as well as the additional enhancing measures by the creation of the cultural preserve. So echoing Commissioner Okuda's statements, I believe that the cultural and natural resources for the vast majority of the property will be enhanced. I would also note, for me, the permanent nature of a conservation easement is that no government body can undo it later on. So the longstanding concerns with this community having future housing development or other development, this will be the final footprint of what can occur, because there will be a third party which will, in essence, own the development rights and will stop anything from happening. Commissioner Chang. You're muted.
Okay, thank you, Mr. Chair. Obviously, we're all struggling with this. This is probably the first time I see that we don't have a motion, but we've got kind of discussion on the pros and the cons. In my view, I see this as this matter being different from what was previously before the Land Use Commission. However, I greatly appreciate Mr. Yoshimori. You really have added great value. You've pushed the envelope very far on this, and I think the Hawaii Memorial Park is willing to give in a lot more than perhaps they would have. But in my view, what is different this time is the Ko'olapoko Sustainable Communities Plan. I recognize that there are some people within the neighborhood that strongly oppose, passionately oppose this, because it is literally in your backyard. And I think at the time that it was originally heard 10 years ago, the Ko'olapoko Sustainable Community Plan supported the way the neighbors felt. But that process subsequently engaged the larger community. And that larger community, they went through a process to have public meetings, they had long discussions. And as a result of that, the Hawaii Memorial Park's expanded area and the cultural preserve is now part of the Ko'olapoko Sustainable Community Plan. And to me, that is a very significant consideration, that it does reflect, as we had earlier testified, I think it's Mahealani talked about good planning. And I think that plan provided the good planning. I think also the many issues that have been raised throughout the hearing, in my view today, there were, I'm comfortable with the adequate measures, the additional conditions that were added. Appreciate the chair asking for those conditions about community engagement, and so too often all we get is complaints. So I appreciate the fact that Hawaii Memorial Park, through Mr. Tabata's representation, is willing to do more. And I think they recognize how important this is, especially to those neighbors who have, Mr. Yoshimura, I think, has dedicated, more than a decade to this. And so I don't want to diminish how, what your efforts have done. But to me, again, I am very comfortable with the cultural preserve. I think that was a heiau it was covered into, I think it was, can't remember the name of the gentleman who found it. He and then started clearing it up, and now it's become, I mean, it's a showcase, and it's got such cultural mana. You go there and you can feel it. So I feel that the cultural preserve, the fact that now Hawaii Memorial Park is willing to pay for a lot of the management that would, those fees or expenses that would otherwise have been borne by the Ko'olapoko Hawaiian Civic Club through Commissioner Okuda's, I think his line of questioning and the fact that the Hawaii Memorial Park is willing to actually put funds towards that management, even if it's done by another organization. But all of these measures, concessions, and again, the fact that the Ko'olapoko Sustainable Communities Plan, this extension is now consistent with that. I find that there are more benefits to this plan. The market will bear whether there's, a need, but I understand that that's a concern. But I guess for me, I see those as the reasons why in my mind this is not the same boundary amendment that came 10 years ago. And so that's what I have to say. Thank you. Thank you.
Okay. Commissioners, Commissioner Wong, you raised your hand, and so did Commissioner Axon.
Commissioner Axon, I'll defer to Commissioner Axon first.
Commissioner Axon.
Yeah, Mr. Chair, I'm kind of agree with you that, a motion is in order before all those discussions. Unfortunately, it kind of taken me a while to kind of formulate some motion, and still I'm not really full in my thought on the motion, but I will try. If it is okay with you, Mr. Chair,
please proceed.
I want to make a motion.
Please proceed.
Mr. Chair, I want to move to approve to amend the conservation land use district boundary into the urban land use district for approximately 53.449 acres of land at Kaneohe, Island of Oahu, State of Hawaii. TMK 14-5-033, portion of Lot 1. With the accompanying conditions prepared by the petitioners. And in addition to that, the additional conditions that was requested and was accepted by the petitioner that was presented by the several commissions. I don't have all those,
I have a list of those. Can I refer to them for you, Commissioner Axon? Yes. A condition regarding the drainage control and basins with language proposed by the intervener with amendments with a small amendment agreed to by the petitioner.
That's correct.
A definition of clean fill, as well as the inclusion of all construction and demolition landfills in addition to specific reference of PVT as they will not be a location for the disposition of clean fill. A condition regarding construction management and communication with the community. A condition regarding endangered species outreach. A specification that an accredited land trust is one accredited by the Land Trust Accreditation Commission, and language regarding the funding of the cultural preserve.
That's correct, Mr. Chair, and that is in addition to the DNO condition proposed by the petitioners under proposed DNO.
As well as the city and the Office of Planning?
That's correct. I believe that's 20 conditions that they have on that.
Okay.
DNO proposal.
Okay. So folks, we have a motion before us. Is there a second?
I'll second that.
Oh, Commissioner
I'll second that, and I thank Commissioner Edmond for stepping forward and Chair Schroyer for keeping track of all those good details. Thank you very much.
Commissioners, I'll give Commissioner Axon and Commissioner Cabral a chance to speak to them, but let me sort of procedurally remind you of where we're at. We're on a district boundary amendment. We need 6 votes in favor of a district boundary amendment for the motion to either move forward or a motion to deny to move forward. If we should somehow fail to get 6 votes to either approve or deny, and we stalemate, my understanding of state law is that automatic approval would take place in this matter. With that, Commissioner Axon, do you wish to speak to your motion?
Point of clarification first.
Commissioner Giovanni.
If it moves to automatic approval, would it be with the conditions applied or would it be just the original?
Would be with standard conditions.
Thank you.
Commissioner not Commissioner, Mr. Ordenker, you're nodding, but I want to make sure to get this on the record.
Yeah, yes, that is correct. If the petition moves to automatic approval, then the only conditions that will be used would be our standard conditions.
Okay. Thank you for the question, Commissioner Giovanni. Commissioner Axon, would you care to speak towards your motion?
Yes, thank you, Mr. Chair. It's been a long hearing, and there's a lot of information that we had to take in. First of all, I want to thank Mr. Yusimori, the intervener. You gave us a lot of information also to take in. And also, I want to thank the petitioner for all their hours that they put in on this one. As you know, this is the second bite of the apple, as you say, for the petitioner. The first petition was denied, as you know, and they come out with a second petition after discussing with community concerns, as evident to strong testimony by Ms. Mayalani Cipher and also the effort of Dr. Tricia Watson. I believe the petitioners and providing us some credible experts to answer our questions, and I believe that if not all, they're kind of pretty much address a lot of community concerns. For example, the traffic, the noise, the gas, and after proper mitigations and the testimonies that I heard that dam supply will be better protected than it is currently protected. The rockfall mitigations really acceptable to me, and to address the drainage improvements and the retention basins. It's part of the conditions, the current conditions now. And and one thing is the creations of cultural preserve, which will be managed by the community itself. And petitioners agreed to help and support that effort. So with that, I strongly ask my fellow commissioners to join me in approving this project.
Thank you, Commissioner Axon. Before I give it to Commissioner Cabral, I want to note there's an attendee who has their hand up. We are now in the portion of deliberation of just the commissioners. So if you have some technical issue, you can place it into the Q&A box, but we're not taking any testimony on this matter or responding to any questions from the public. Just as if this was a physical meeting and suddenly somebody in the audience wanted to stand up at this point, they would not be recognized by the chair. Commissioner Cabral, do you wish to speak to your second, followed by Commissioner Okuda?
Yes, I will. Thank you, Commissioner Edmond, for stepping forward with this, and also for clarification from Chair Sawyer and Director Orndecker about the importance of this vote, because to not make a vote with all of our conditions, what I think would not be, in my opinion, what I would want, or what I think would be the better thing for our community. So I think that the large number of conditions that are being added on to this motion, and the willingness of the petitioner to accommodate those or be required to accommodate those is in fact going to make this project better than originally requested, and also I think will hopefully be better for the community in the Damselfly, the cultural center, and also hopefully this extra effort that has been agreed upon today with the drainage basins, and that will hopefully make that even safer for the community below than if nothing were to happen and we just left it as God would take care of it with flooding from up above. So I'm very hopeful that this entire package will be an improvement for the entire community. And so therefore, I'm willing to second and vote for this motion. Thank you.
Thank you, Commissioner Cabral. Commissioner Okuda.
Thank you very much, Mr. Chair. I first have a question either directed to you, Mr. Orendenker, or maybe our Deputy Attorney General, Ms. Chow. The statute requires 6 votes in favor of a boundary amendment. Are we required to, by statute, to have 6 votes to defeat the motion or defeat or reject the petition, or is it 5 votes, which is majority of, is it majority of quorum? I mean,
Mr. Orendenker, followed by Ms. Chow.
I'm going to defer to Linda on this, but my understanding is that 5 votes would be enough to deny the. For approval, you need supermajority, but denial, the statute doesn't refer to the number of votes that are necessary.
Yeah, the statute is silent as to how many votes are required to deny it. I think because a denial basically maintains status quo, then I think the interpretation that a simple majority would be sufficient to maintain status quo is probably consistent with the statute.
Thank you, Dan, Linda, and Gary for that question and for my misstatement earlier. Mr. Axon, Commissioner Axon.
That means it's just a majority of the present commissioners to deny?
Of the quorum or of the total number of sitting commissioners, Ms. Chow?
I believe it would be majority of the quorum. No, Mr. Orendenker is disagreeing with me.
You're muted, Dan.
I'm going to unshake my head. I'm not sure.
Mr. Chair, thank you. I don't think we need to answer this very minute.
Okay.
If it becomes an issue, then I'm sure, Mr. Chair, you will take the appropriate action, including recess, to determine what the meaning of the result is.
And right now we have before us a motion in the affirmative.
Yes. And I like to speak to that motion. I hate to put it that I disagree with the motion because I'm still kind of struggling with some of these things. But let me tell you why my inclination is to vote against the motion. With all due respect to my fellow commissioners, Mr. Axon, especially who I have a lot of respect based on his years in the industry. I know they tell us don't use cliches like if it ain't broken, don't try to fix it. So I'll avoid cliches and just try to look at what's in the record, okay? And I think what this case right now, in my view, comes down to what is reasonably certain and what is maybe not certain or not clear in the record. I think the record is pretty reasonably certain that so far, number one, no one has been injured by falling rocks. There have been no massive flooding of the downslope neighborhood. There's no massive excavation going on right now of the mountainside, the Oniava Hills, and there's no runoff going into Kaneohe Bay from excavation of the Oniava Hills. There's presently no risk, which was stated in the final environmental impact statement, about what the risks were during construction, which I believe at the final environmental impact statement, page ES-5, even though there was a discussion that these risks could be mitigated by best management practices, the EIS specifically stated, and I quote, significant short-term impacts, close quote, can be expected from the expansion and construction. You know, I know life is not perfect and we have to weigh cost benefit, but at this point in time, there's a real concern on my part about whether or not the benefits, which I do recognize will take place from granting the petition. The benefit is primarily the conservation easement and the cultural preserve, whether that's really outweighed by the pretty certain effects or impacts of what's going to take place with the proposed boundary change. There's no question in the record that there will be significant excavations into the Oneava Hills. Some cuts, according to the record, could be as high as 100 feet. I believe the reports indicate that there might be 457,000 cubic yards of materials excavated. There's going to be significant fills with a leftover of possibly 47,000 cubic yards of materials to be disposed of somewhere. Now, a positive view or outcome of these hearings have been the representation that the amounts which were supposed to go to the PVT landfill, according to the final environmental impact statement, will not be going to either PVT or a construction disposal site. But having that much fill to dispose of, or that much excavation to dispose of, I still have a concern about impacts on construction landfill. Because even though there have been an argument that this boundary amendment will help preserve or create jobs, the reality is if we as a commission do anything which might negatively impact a construction debris landfill, especially with the signature into law about the half-mile buffer around landfills, this project very well creates some risk that we could fill up existing construction landfills to the detriment of many, many other construction jobs, which frankly we cannot afford to lose. And the question is, who gets what at the end of the day here? The record indicates that the estimate of income coming off of the sale of the expanded cemetery lots quite possibly could be in the neighborhood of $500 million. Now, Hawaii's constitution makes clear that we're not prohibited, or the state is not prohibited from developing land, even conservation land. But the Constitution of Hawaii makes very clear that it has to be done with the eye of self-sufficiency. And the applicant has also made clear that it will not agree to a condition requiring a certain sum of money be kept in the community. So very well, the trade-off here is we agree to have these massive excavations of the Oneava Hills, and the people who make the money off of these massive excavations have no duty or obligation to keep the money in the community. And this is not just a simple excavation. What's concerning is Mr. Lim's testimony that even with rockfall mitigation efforts, there is a zone of danger here. In other words, yes, it's true. Right now, people are not prohibited from going into the conservation area. And in fact, under Hawaii state law, there's a requirement to allow practitioners to go into undeveloped area. But what will take place here with an urban boundary designation is we are essentially going to be inviting the public to enter into what even the applicant's engineer has testified to as a potential zone of danger, which potentially can lead to serious bodily injury, or if things really turn out badly, into possibly being deceased. And so when we look at these trade-offs again, it's really a difficult thing about trade-offs. Now, I do agree with, to some extent, with Commissioner Chang, that the record of this case really indicates that we have really tried to comply with Kapa'akai. But there's a little bit of me that has some doubt about whether or not we have a complete record, mainly because there is a delegation of important functions to the manager of the cultural preserve, which is not spelled out. And the applicant has the burden of coming forward with sufficient evidence and sufficient documentation. I can't, in my mind, understand why these details, since these questions were being raised at numerous earlier hearings, why these details could not have been brought out so we would not have this potential Kapa'akai issue. But the final thing about the trade-off is this. I'm not sure if the applicant has met the standard or the burden of proof to demonstrate a real need for these additional cemetery plots. The evidence, as far as I can see, are really conflicting about whether or not these cemetery plots are needed or not. And if we go forward with this boundary amendment, we're basically going to justify major alterations of the landscape, major significant risks of runoff and other types of adverse impacts into Kaneohe Bay. We will create a risk that if these proposed drainage plans don't work out, there could be significant flooding of the downslope neighborhood. And in the end, we may also be creating a significant risk to people who come into this urban area thinking it's safe, not realizing that there's document rockfall hazards. So, you know, the cultural preserve, the conservation easement, that's really, really enticing. You know, I compliment Mr. Tabata and Mr. Matsubara for really trying to address these issues, you know, and it shows they do a good job when it really has me conflicted. But at this point in time, given the matters that I raised, especially the provision in the Constitution which talks or admonishes us to look towards self-sufficiency, I cannot see a justification for a project with these types of downside risks, which will basically reward the world's largest funeral mortuary cemetery company with possibly $500 million for the exchange that we get, even though the cultural preserve is a very positive thing. Thank you very much, Chair. Thank you to my fellow commissioners for bearing with me.
Thank you, Commissioner Okuda. Commissioners, we are in deliberation. There's a motion before us to grant with conditions. Commissioner Wong.
Thank you, Chair. I'll be voting in favor of the motion. I first thank the intervener, Mr. Yoshimori. He brought up some very good points. And, you know, some of the points were, to me, about Kapa'akai, the drainage basins was, and even about the dragonfly was, damselfly, sorry.
Damselfly.
Got me questioning. But what happens is when we had the hearing, one of the issue was if we don't do anything, Hawaiian Memorial Park will not need to do anything about the damselfly. And the damselfly just could die off just because excess heat, no water. So, you know, they are going to do something. So that's one point why I'm supporting the motion. The second thing is they agreed to increase the drainage basin to a size that is needed, that is past the needs of the statement of the law. So to me, that is very important, and hopefully it will protect Mr. Yoshimori and all the neighborhood people in the area. So that's another reason. The last reason is they're getting the Kalapoko, you know, someone to take care of the land. So, and giving them the rights to continue to go into the land. So that's the last reason. So that's why I'm supporting the motion. Thank you, Chair.
Thank you, Commissioner Wong. Commissioners? Commissioner Giovanni.
Thank you, Chair, and thank you to my fellow commissioners and all the participants in this incredible docket. It's been a real experience for me, the newest commissioner. If I turn back the clock even a week, I had a half a dozen issues with this proposed project. If any one of these, in my mind, were not adequately addressed, I would have not been in favor of this project. I would have voted against it. And notice that I said the word adequately or sufficiently as opposed to absolutely or on a guaranteed basis, because for many of these things, there are no absolutes. And so we're called upon to make judgments in the best way we can. One of the 6 items, one item that's not one of these 6 items is whether this project is financially feasible or justified. That's a business decision by the project owner, in my mind, who would be investing tens of millions of dollars. A lot of that would stay in Hawaii, and it would serve the needs and desires of Hawaii people. I don't see that this is a project that's really designed for burials of people from outside of Hawaii, although there might be a few. But it's really something that's serving the people of Hawaii and Oahu in particular and the families thereof. And we heard from a lot of them. So I want to go back to these 6 items that were so troubling for me. And the first is, is the project going to adequately address climate change? And that came in 2 forms. One with the deforestation, and secondly, with the increased and more aggressive storm events that are expected to occur in the near future. And I accept the game plan and the commitments of the petitioner to plant tree for tree a replacement on Oahu to mitigate the effect of deforestation on climate effect. With the size of this property, I don't think in the grand scheme of things, it's going to be a great adverse effect in the first place, but nonetheless, it is an adverse effect. And I think no matter the size, it's incumbent upon all of us to do what we can, our part. So I think that the tree for tree replacement, although not perfect, because the new trees will take a little bit of time to grow, is the right kind of mitigation for that part of the climate change effect. The second had to do with the more aggressive storms, and going with the 24-hour worst case storm in the 10-year period as opposed to a 1-hour storm is really important. You're talking about a 15-inch water storm, of which we've had 2 on Kauai in the last year. So they will occur and they will create havoc. And so you need to design for that level of a storm. And I think the willingness to do that is a positive. We might have a bigger storm, but nonetheless, I think we're, again, sufficient, adequate, and responsive by the petitioner. The second issue I had had to do with the endangered species and the damselfly. And I've tried to follow all the testimony and all the Q&A, and simply said, I come away with the perspective, the judgment, that the damselfly is going to have a better chance, not an absolute chance, but a better chance by virtue of the project than it would if the project does not go forward, because there's going to be attention paid to it. So I think we checked the box on that one. The third one had to do with the cultural issues and the archaeological issues. And for this, I defer largely to my fellow commissioners and to the expert testimony that's on the record. And it sounds to me like that the petitioner is taking an adequate and sufficient response, and one that's sincere, and they want to do right. I'm open to listen to any of my fellow commissioners to say that it's not adequate or it's not sufficient, but in my judgment, listening to the record, what's on the record, it is. The fourth one has to do with the disposal of clean fill. And we've talked about that a lot, including today. And the petitioner has moved considerably from where they were 2 weeks ago, 3 weeks ago. And they moved in the right direction. So I do think that there will be a market, there will be an opportunity to dispose of. It's a lot of fill, it's a lot of clean fill. We've defined what it is. They'll find a market for it in other construction projects. Just think of H3, think of the rail system. There will be big projects that move earth and require fill. But rather than take the simple route just to dispose of it, we're forcing them through this condition to proactively find a home for that clean fill that is, again, in a positive way, because construction projects that need clean fill, they welcome it. And so hopefully that occurs. So I think we have sufficiency there. And then the last one, not the last one, but the fifth one, and it's the one that I actually lost sleep over. I mean, to think of the people living in the homes right below, and whether or not they're at risk of a flooding episode by virtue of the construction activity occurring in combination with an aggressive storm. So I do think it was very important that the petitioner moved to agree to language proposed by the intervener. And I respect the fact that the intervener is putting forth that language on the condition that this project is approved, a project he opposes sincerely. But nonetheless, I feel that the language is appropriate and is adequate to minimize the risk. We're not, again, no absolutes here. And then the last condition that I cared about was continued community engagement. Hate to see, I mean, this is a project that is going to affect the community in many ways, whether it be day-to-day construction activities, whether it be ongoing negotiations with the cultural preserve, et cetera. So requiring that condition was important to me. So I looked down my list that does not include financial feasibility, and I kind of checked the box one by one that they're all sufficiently and adequately addressed on balance. And so for all those reasons, I will be voting in favor of the motion.
Thank you, Commissioner Giovanni. Commissioner Chang.
Thank you, Mr. Chair. I too am going to be voting in favor of the motion. You know, this is, and Commissioner Okuda, I greatly appreciate always what you bring. Well, most of the time.
Do I need to call a recess? No.
I do appreciate the sincerity and what you bring. For me, the role as a land use commissioner, it is to exercise independent judgment, but it is to look at the will of the community. And we have heard, I mean, Mr. Yoshimori and the neighbors, heard them clear, they've been consistent, they've been passionate. But for me, what is really striking is the Ko'olapoko Sustainable Communities Plan. That is a planning process that involves a greater community engagement process. It is one that looks, it is a rational, reasonable planning document. And I believe as a land use commission, we do have to pay attention to that. I may not have gone through a methodical checklist as Commissioner Giovanni, but listening to the testimony, listening to, in particular today, there were the commissioners pushed Mr. Tabata and the petitioner to take on some conditions that they may not have originally been willing to do. And to me, that demonstrates, I believe, a sincere desire to be a good steward to this land. As you know, these Ko'olapoko Hawaiian Civic Club, I never take them lightly. And Yayokuri, I mean, you've said that before. You know, Mahealani and that group, they would not come on to a project that they did not believe in their hearts was right for this community. So I give great deference to that. But again, for me, it is the will of the community. I believe the culture preserve. I believe that the Kapa'akai analysis has been adequately addressed in all of the documents. And I appreciate always the commissioners asking those hard questions. But in my mind, the cultural preserve and the mitigation measures, the long-term commitment to involve the Ko'olapoko Hawaiian Civic Club, that I think is an enhancement. That's stewardship. That is a positive. And so for all of these different reasons, I will be voting in favor of the motion. Thank you, Mr. Chair.
Thank you, Commissioner. Is there anything further, Commissioners? Commissioner Axon.
Chair, I just want to add to Commissioner Chang's comment that, you know, I consider Commissioner Okura as the conscience of this commission.
Thank you, Commissioner Axon. Where to begin? I have a friend who's a meditation teacher on Hawaii Island, and his teacher's teacher was a revered and elderly monk who was asked, you know, now after having practiced meditation your entire life, how do you meditate? And he said, it's really simple. He's like, on the in-breath, I say to myself, everyone I know will die. And on the out-breath, I say, and so will I. I think one of the funny things about this docket is the subject matter, something that we generally push away from. We love to think of ourselves as, we love to not think of our mortality. And on a personal level, on the one hand, it's not a burial practice that I intend to see for myself, to be buried in the ground. I intend to be cremated. That's what my wishes are. But I did, prior to my serving on the Land Use Commission, have the opportunity to serve for 3 years with the Oahu Island Burial Council, which really deepened my knowledge and respect for the significance of burial practices to people. And one thing that hasn't been highlighted in this discussion has been, you know, I will use the term, in nothing more than what was just racism, traditional practices were outlawed until very recently. Traditional burial practices, things that were allowed for thousands of years, suddenly became illegal in the state of Hawaii, and only through great effort, including from the Ko'olapoko Hawaiian Civic Club, was there a legality to once again have Native Hawaiians do traditional burial practices. But absent a place to do it, the legality of the practice is kind of meaningless. And so one of the things that I find very meaningful about this project is not just the provision of traditional, so-called traditional cemetery plots as an expansion, but also the provision of an area for traditional burials. I'm conflicted, but really for many of the reasons about balancing, I'm going to vote in favor of this motion. And it's not out of a, it's with regret for the really incredible job that the interveners did. And not just the technical ability that you brought to it, but the respectful nature, more respectful than colleagues with JDs who sometimes appear in front of us. And so my vote is not a comment on the manner in which the interveners have pursued this, but it is a comment on what the law lays out for us to do as criteria and what we believe is justified and for the betterment of the state as a whole. So I know I've rambled a bit. It's a hard decision for me, but I do feel on balance that this area in particular, Kaneohe Bay, and actually in terms of flooding, the neighborhood will be better off if this project is granted than if it's not, and certainly better off than if it's automatically approved without any conditions. If there's nothing further, commissioners, I'm going to ask Mr. Ordenker to poll the commission.
Thank you, Mr. Chair. The motion is to approve the petition with conditions contained in petitioner's proposed decision and order, and conditions as stated by the chair and discussed by the commissioners, including but not limited to drainage control, definition of clean fill, use of the PVT landfill, management of the management of the cultural preserve and others. Commissioner Axon.
Yes.
Commissioner Cabral. Commissioner Cabral.
Yes.
Commissioner Chang.
Aye.
Commissioner Okuda.
No.
Commissioner Giovanni. Commissioner Giovanni.
Aye.
Commissioner Wong.
Aye.
Chair Scheuer.
Aye.
Commissioner Ohigashi is absent. Thank you, Mr. Chair. The motion passes with 6 affirmative votes.
Thank you very much, Mr. Ordenker. I will instruct the staff to prepare a decision in order consistent with the commission's decision today. There being no further business for today, I'd like to thank all of the participants and the commissioners for their stamina, especially, again, the intervener. And we are in recess until 9 a.m. tomorrow, where we will take up action item number SP 97390, a motion for reconsideration. Thank you to everyone. Be well and safe. It's 3:07 p.m. We're in recess till 9 a.m. tomorrow morning.
Commissioners.
Thank